All rise. All persons having business before the Honorable Associate Judges, now residing over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please be seated and come to order.
Good morning, everybody, and welcome. We have 3 cases on this morning's calendar. Starting off with number 22, CV 760, Alexa Moore versus District of Columbia et al. Whenever you're ready, counsel.
Good morning, Your Honors. May it please the court. I'm Arnold Abraham on behalf of the appellants. I'd like to reserve 5 minutes for rebuttal. Today's case is about applying laws, in fact, an ancient law, to modern technology, the 21st century information technology. But it's not a difficult case because the question is, does the complaint have enough in it to defeat a sovereign immunity on a motion to dismiss? There are pages and pages containing detailed allegations.
I don't want to distract you, but I wonder if you could start with the threshold issue,
Yes, Your Honor.
or what I would consider to be more of a threshold issue.
At this stage in the proceedings, we are dealing with a 12B6 standard on a motion to dismiss. We have interpretation of the facts most favorable to the plaintiff, construing the complaint liberally and drawing all reasonable inferences in favor of the plaintiff.
But do we have a final order?
Your Honor, that speaks to the question of jurisdiction. We agree with this court that you do have jurisdiction. This court issued clear guidance on what is required before the case is prepared, right before appeal. We complied specifically with the guidance that was issued by this court.
But I thought in our briefing order, we reserved the jurisdictional question for this argument.
You offered that the
So we haven't
appellee,
decided it yet. We're here to talk about it with you.
you offered that the order said that the appellee may brief their argument as to why this court does not have jurisdiction, which would be true.
And they did.
Hmm?
And they did.
Yes, Your Honor.
Right.
And
So
we rebutted that in our reply. And I was going to save that for the rebuttal, but I could address that now if you wish. This case is nothing like those cited by the district. There was clear action by the court. It was not the parties that determined finality. It was the court that determined finality.
Well, can I ask you, I mean, I think the concern is the following, and I'm just interested in your response to it. So ordinarily, if a plaintiff sues two defendants and the trial court says, I'm going to grant judgment to one of the defendants, like motion to dismiss by defendant A, but I'm continuing proceedings against defendant B. Ordinarily, not a final judgment, not appealable. You can get certification from the trial court sometimes, but ordinarily without the kind of approval of the trial court in special circumstances, you can't appeal that. If, however, a voluntary dismissal of the remaining party without prejudice, which could then be, undone thereafter, creates finality, it seems like there's a pretty easy workaround to what seems like, sort of the general rule that we want the case to be all the way done and one appeal. And rather than kind of the opportunity for tactical workarounds on that and possible piecemeal appeals and like, so that's the concern that animates the contrary view. And I'm interested in your, whether you think we shouldn't be concerned about that or what your response is to that concern.
Well, Your Honor, the essence is that your question is there a difference between dismissal with prejudice and dismissal without prejudice? And this issue was previously raised. The court had an opportunity to weigh in on that, and it did not. The case law does not support that there is a significant difference across the board in this, whether the dismissal is with prejudice or without prejudice. Effectively, by dismissing the other defendants without prejudice, it was as if they were never part of the case to begin with. So there's literally an infinite number of potential other defendants that could be brought into any case.
Well, is your argument then that we should just take these questions on a case-by-case basis, depending on the facts? Because, your opponent cites a DC Circuit case, the Blue case, which you both talk about, which does seem to set out a rule. It is true that it has facts that are quite distinguishable from this case. There's a tolling agreement and a settlement, but it seems like if Blue had these facts before it would have done the same thing. Why, you know, what do you think this court should say about the issue generally?
That first, I would say that if the same facts were before the blue court, it would have come up with a completely different answer. The rationale behind blue was that the plaintiff asked the court for a final order and the court denied them. They said, we're not going to give you a final order. Here, we asked for a final order. The court said, here's what you need to do to get a final order. We did exactly what the court asked us to do. And then the court said, okay, you now can proceed to appeal. Additionally, the blue court, the main reason they gave is they said that the courts should be the arbiter of what is finality, not the parties. Again, here, the court said that the order was ready for appeal.
And when you say the court, you mean this court in the motion, in the ruling of the motions division is what you're
Yes,
you're
Your Honor.
interpreting that as kind of already deciding the question, and then you implicit in that is that it didn't make much sense for this court to direct that your opponent brief it. If we already decided it, that wouldn't be a very sensible thing to do. So you think that was just a kind of an imprudent step by the court to direct briefing on the topic?
Well, the court, this exact language you used was they briefed the argument as to why it still must be dismissed, not that it could be dismissed. You had the choice. This court has discretion. And very importantly, the case law for this court is that you have not construed the concept of finality in a rigid fashion. What the district is asking is they should dictate what your rules are on how to achieve finality. They gave a very lengthy description of hoops that we'd have to jump through to meet their criteria. You have given the criteria, we met the criteria. You could have given other criteria.
I'm confused as to why you think we gave you criteria in an order that said, please brief this in the merits briefs.
Well, on the July 18th order of this court says.
This happens all the time where issues are raised to a motions panel and the motions panel says, you know what, this seems more complicated than we usually handle as a motions panel. We're going to defer deciding this and hand it over to the merits panel. We're the merits panel. Now we're going to consider the jurisdictional question.
That language was not in the court's order. There was no indication that they felt that they did not have enough information to make the decision. They made a decision. They said if they wish to present additional information, they can make their argument. Jurisdiction is always available.
Can you tell me though, what language in the order do you take, the order that you're referring to, do you take as the motions division having decided the question? And sort of said, this is, to you, if you do the following, then you're good to go. Could you tell me what language in the order you think clearly communicates that?
Well, first there were two orders. There was first the order on June 8th that said that the case was not final and that here's what you need to do.
Well, that's your paraphrase. Like, can you tell me what when you say that the order said to you, here's what you need to do? I'm quite confident it didn't say that. So obviously that's a paraphrase. So can you tell me what's the exact wording of the order that you think was kind of a ruling that if you took certain steps, that would be adequate?
The exact wording is the order is non-final because it does not resolve all claims before closing the case. And then it said, appellant may file a motion to reinstate the appeal after filing the necessary notices in Superior Court. There was no
right, and that would, I mean,
that,
that seems to say you can do whatever is necessary in the trial court, and you can file a motion to reinstate, and then we'll consider whether it should or shouldn't be reinstated.
yes, Your
And then
Honor.
we did reinstate it, and when we reinstated it, though, we said we're reinstating it, but the parties are. I forget whether we directed or invited or what the briefing of the question of whether what had been done in the trial court to attempt to fix the finality problem we had earlier seen was adequate. So I guess I'm a little doubtful that this has already been decided by our prior orders.
It certainly was not decided that you don't have jurisdiction, because we wouldn't be here today if that was the ruling that had been made.
That's
So
certain.
there was, at that point, it was, but moving on the presumption of jurisdiction, that they had to rebut that presumption.
Can I ask you whether there is anything in the record in the trial court or in any filing in this court that explains the reasons for the voluntary dismissal of the remaining parties after our original order? Like what the reason for that voluntary dismissal was? Is there any indication of why that was done?
There was nothing in the record, just that the previous defendants were dismissed without prejudice. So we dismissed the final defendants without prejudice as well. Part of it, we don't have discovery into the matter. So it is possible that once we do discovery, we may find that there is potential liability.
No, what I mean is when you went back and voluntarily dismissed the remaining defendants, one certainly could have, if one had wanted to, in whatever was filed to do that, given an explanation for why that was being done, which I just don't remember there being one, nor have I heard any suggestion about a reason for that, other than what your opponent infers, which is it was all, I don't mean this in a disparaging way, but a strategic decision to try to create finality that didn't otherwise exist.
It's not on the record, but I can tell you that we dismissed them because they preferred that they had nothing to do with it. So without discovery, we were willing to take them on their face of their statement and move on to the main plaintiff, which is main defendant, which is the district. Anything the contractors did was on behalf of the district anyway. So the only issue to really be resolved is there sovereign immunity or not? Because with sovereign immunity, the contractors wouldn't be liable anyway.
Can I ask you about when you shifting to the merits of the dismissal on sovereign immunity grounds? When you started, you said that you believe that the complaint has in it adequate allegations to survive a motion to dismiss on sovereign immunity grounds. Do you think that's required? Do you think the complaint has to include allegations sufficient to defeat an affirmative defense? Or do you think that if the affirmative defense is raised, you could, in opposing it, say, well, we didn't have any reason, we were laying out the elements of the causes of action that we had. We didn't really lay all this out, but here is our, here's what we're alleging that runs beyond the complaint that is, would explain why some of what we're alleging should survive a motion to dismiss on sovereign immunity grounds. Do you think that's something that could have been done, or do you think you were really limited to what's exactly in the complaint?
Well, Your Honor, we did give a more supplemental explanation because we're surprised that the question even arose, because at the pleading stage, there was enough there. It was as if the court read the complaint as having one sentence: something went wrong in cybersecurity and it was ministerial. If that's what the complaint said, we could understand how it could be dismissed at this stage. But it had pages and pages of specific things talking about implementation, not policy.
What's your best, if you were going to pick one specific allegation in the complaint that you think, well, just look at that and you can tell that that is ministerial rather than discretionary. What's the most specific kind of exact allegation in the complaint that you think would best illustrate that point?
Failed to maintain security systems consistent with industry standards. Failed to implement proper security procedures. I mean, I could go on and on, but it's very there are some things that talk about design and architecture, but there's a lot of things that talk about implementation of that architecture. And on top of that, one additional point is there is statutory directives that apply in this area to the maintenance of records. And though that statutory guidance precludes the entire discussion of discretionary versus ministerial.
Do you really think so? I mean, the statutes are pretty broad. They just say you have to maintain these records, but they don't say how. And that seems to invite some policy decisions. And maybe underneath those policy decisions, once those policy decisions have been made, there's some ministerial questions, but it's hard to see where that line is based on the record that's before us.
It is sometimes hard to distinguish between ministerial and discretionary tasks. And that's why this court says there's a detailed
Well,
analysis.
It's
that's
not even
required.
that we can't even get to the point of drawing the line between discretionary and ministerial tasks because it's hard to see in the pleadings the policy decisions that have been made and then the ministerial actions that have or haven't been taken in your view.
In the pleadings, we did not plead the specific statutes that constrain them, but we did speak in several areas to the fact that they are constrained by policies and directives. We've mentioned in the brief the specific records retention, speak specifically to retention for the police department of records in a digitized form. To say that the security of those records is not part of the requirement to maintain them would be as if you could put them on a public park bench. I'm maintaining them out there. Anybody can come by and
Well,
pick them up.
What is, you mentioned the failure to maintain consistent with industry standards, and this is something your opponent takes you to task for, like what standards under what, which group is putting forth what standards. But what if the district, the higher ups all had a meeting and decided they were going to, maintain their system inconsistently with industry standards because of budget considerations or something. They had this kind of cut rate program here that they're going to use and it falls short of industry standards, but they've made that decision and that's how they're maintaining the system. Is that discretionary?
If that is, first of all, it's a inference clearly in favor of the defendant. So that's against the standard of review. But if they made a decision, this is going to be our cybersecurity, and they followed that decision, yes, that's discretionary. However, we don't know if they actually followed their own policy. We're asserting that they did not. We have another clear allegation that they failed to follow their own procedures. So,
And what's the specific respect in the complaint in which that's alleged? I mean,
in paragraph 290 of the complaint, we state that they failed to follow their own privacy.
I understand that, but this is more really in some ways almost a 12b6 kind of question and not so much distinctively a sovereign immunity question. But do you think a complaint is adequate if it says, we're suing some entity? Let's imagine it's not even a governmental entity, so you don't worry about sovereign immunity. And here's our complaint. It says the following: they failed to follow their own policies. It doesn't say what the policies were or what the failure was. Would that be an adequate complaint under 12b6, or do you think that might be inadequate?
That alone might be inadequate, but the complaint's supposed to be read, the entire complaint. It's 5 pages listed. So several of the things specifically that we talk about, for example, failed to detect the breach. So that they are read together. Not following their policies is what led to failing to detect the breach. Not following their policies is what we talk about not encrypting. We talk about not updating their software, not applying patches, not configuring firewalls.
And does the complaint allege, or do your pleadings filed in connection with the motion to dismiss contend that there are actual district policies about encryption that were not being followed, or using patches?
At this stage, we don't know the content of their policies, but we do know, in addition to what we mentioned, I've uncovered a DC code on automated data processing, and I will subsequently file this reference, DC code 213.02. It says the mayor will establish standards for storage and security of information on their computers. Your Honors, my clients here are police officers. They understand the importance of sovereign immunity. but it just doesn't apply in this case at this stage. If it's not, does not need to be complex, if you just delete the word cyber and look at security. Once the security system was put in place, the district had a duty to maintain it. Failure to maintain it according to their design is a failure in ministerial actions. I see I'm out of time. If I could have some time for a rebuttal still.
Yes, of course. We'll give you a couple of
Thank you.
minutes for rebuttal. We'll hear from Ms. Anderson.
Good morning, Your Honors. Stacy Anderson on behalf of the District of Columbia. Your Honors, I'd like to begin with the final judgment issue. It is the district's view that this appeal should be dismissed because there is no final judgment in this case, nor is there a certification under Rule 54B from the trial court that would authorize an interlocutory appeal of an order that failed to dismiss or dispose of all of the claims in this case on their merit. We do have the September 9th order from the court closing the case, but on its face, it fails to do anything with respect to two of the contractor defendants. But beyond that,
Before that order, the other defendants have been dismissed, am I right?
so
Voluntarily?
correct, Your Honor, the district and then three of the IT contractors had been voluntarily dismissed without prejudice. That's
So
correct.
why doesn't that create some finality? Reading the September order and the March and June orders kind of as a package.
Again, Your Honor, two of the defendants, again, were still in the case at that point in time. So we'd say that we didn't dispose of all of the parties in the case. But again, it's our position that those dismissals without prejudice were a ploy to manufacture finality in this case to get this order dismissing the district before the Court of Appeals. And there's a process in place for that under Rule 54B, and that simply requires a motion to the trial court to certify a order judgment that disposes of less than all of
But
the.
would
you-
the,
oh,
oh, sorry,
You
go
go
ahead.
ahead. Would you be making the same argument if the dismissal were with prejudice? Yeah.
No, Your Honor, if the dismissals of all the remaining parties was with prejudice, then no, we would agree there's a final order in this case.
But even
Because-
if there was the same motivation, right? You're just trying to get to the Court of Appeals, so you'll dismiss your claims against the other defendants.
Right,
With or without prejudice.
Your Honor, with prejudice ensures that there's not going to be additional litigation in the trial court. Again, the final judgment rule is focused on ensuring that the proceedings in the trial court are finalized. And there's only one appeal from the underlying case.
But I
So-
thought we were not insured of that. If I understand your argument, you don't think the voluntary dismissals that were before the dismissal of the district should be analyzed the same way. Is that right?
I would agree, Your Honor, that the dismissals before the district would be analyzed differently. For example,
And doesn't that mean that it's possible that after, assume that imagine that what had happened was there had been voluntary dismissals of all but one of the contractors before the district got dismissed, then the district is dismissed. District's motion to dismiss is granted. And then there had been a dismissal with prejudice of the remaining contractor.
yeah, Your Honor,
Then
that's
you would say, wouldn't we have the possibility of multiple appeals? Because you could have the appeal relative to the district. And then there's still these other folks floating around who were voluntarily dismissed before the district who could bring an appeal.
correct, Your Honor. Again, I think the focus on is there an effort to manufacture finality through these voluntary.
I get that. I was just,
So the
when you said
timing-
you were guaranteed, I
Yeah.
just, I thought it might be a bit too far to say we're guaranteed to get only one appeal under the doctrine. that
Correct, Your Honor. And I can give you an example from this case. There were originally 9 IT contractors and they filed in the initial complaint and they filed an amended complaint that did not include 4 of them. Our argument here today is not that the fact that there were 4 additional IT contractors in the original complaint, the court lacks finality or that there's no jurisdiction here. So we're not basing on that.
And
What we're looking
if
at.
it was, if instead it's kind of a subjective purpose that you're worried about, imagine that there had been briefing on a motion to dismiss and, there'd been argument on the motion to dismiss and maybe the trial court had sent out like a proposed order dismissing for comments of the parties. And then imagine that the defendant voluntarily, the plaintiff voluntarily dismisses without prejudice everyone else in the case, and says, the reason I'm doing that is I'm expecting a dismissal ruling and I want to get finality, and then, I'll be able to take an appeal, and then I'll be able to reinstate as to everybody.
Yeah,
Is that, that's fine, or do you think?
No,
that
I
this
think
creeps
that,
over?
I think that changes the calculus, Your Honor, because there you have direct evidence of an intent to circumvent the finality requirement in the Rule 54B certification process.
And does that
But in
work
terms-
symmetrically in the back end? So at times it seems like you're advocating a kind of a flat rule, which is any dismissal without prejudice that is after a dismissal with prejudice and kind of creates finality post some actual dismissals on the merits, just can't create finality. But assume a hypothetical, I have off the top of my head, I can't think of a plausible one, but assume that it is very clear and undisputed that there was such a subsequent, post dismissal of the district on the merits, dismissal without prejudice that was not for strategic purposes. Imagine you could tell that there was some other reason why it was dismissed without prejudice and it wasn't first strategy. Would you say that's fine? It really is kind of a subjective question of abuse, or do you have a flat rule? That's why, because you don't have a flat rule at the front end apparently. So I'm just
Right.
curious if you have a flat
And
rule at the back end.
again, based on the case law, the examples I gave you on the front end, the DC Circuit has addressed that issue and has held that earlier dismissals. The timing is relevant to the consideration of whether or not there's this effort to manufacture finality. So on the back end, after, I would say that I think we are advocating for a fairly hard and fast rule that any voluntary dismissal without prejudice post a judgment from one of the other parties would at least trigger a presumption that the dismissal was intended to manufacture finality. And I think here, there's nothing, again, in the record that would indicate any reason why these dismissals were undertaken other than to get the district into the Court of Appeals sooner rather than later. But as I've said, there's a process in place for that. It's what Rule 54B is there for. And it gives, that rule is designed to effectuate the policies underlying the final judgment rule, right? It gives the trial court control over when the judgment's entered. It clarifies for the parties when we have a final appealable ruling.
What about all of our cases talking about the importance of pragmatism and being flexible in matters of finality? And while you're answering that, do you think it matters at all that your opponent's arguments about this court basically luring that party into this situation?
Okay, I'll take
Okay.
the latter
Yeah.
question first. I don't think the court lured him into this situation. We were clear in our briefing. We set out the case law. I think it's very persuasive case law. I think there's a broad consensus that supports our position. So the plaintiffs would have been on notice from our filings. But in addition to that, motions panel's determinations, even if the court had held that it has jurisdiction, unless that ruling is made with prejudice to consideration by the merits panel is always able to reconsider motion panel rulings. So I don't think there's anything in the court's order that signals that that if you do these dismissals without prejudice, we agree you have jurisdiction. It's clear that the motions panel deferred to the merits panel on that. So I don't think there was any lulling here.
So as matters stand right now, Ms. Moore, has what the district concedes as a final order against the district, and a non-final order against some other defendants. And so what should happen if Ms. Moore wants to proceed with this appeal? Ms.
Sure.
Moore should go back to Superior Court and either move to dismiss with prejudice against the remaining defendants or seek a Rule 54B order from the
Correct.
Superior Court.
Correct.
What if Ms. Moore sensed that this court were inclined to adopt the government's rule of you have to have a dismissal with prejudice, and she went back to Superior Court this afternoon and said, I'm dismissing without prejudice? What then where would we be?
Sure, the court would have a final order. I mean, if counsel for Ms. Moore wants to represent to this court today that she's willing to stipulate to dismissal of prejudice of the remaining defendants, that would be acceptable to the district, as long as that's reflected in the court's opinion that's what happened. So
Or she
yes,
got a Rule 54B ruling while this case was still pending.
I'm not sure the court would have jurisdiction to do that without a remand. We would not oppose a record remand for that if the court were so inclined. Again, the district here is just concerned with ensuring that the process is followed in this case, as in many cases, where it has an interest in ensuring that the final judgment rule is adhered to by plaintiffs. And so we would be satisfied if there was compliance in this case.
Do you consider that there might be situations where you would deviate from that rule? You did describe it as a relatively hard and fast rule, but are there ever situations, some of the cases, like the Ninth Circuit case seems to suggest that they're going to look and see whether the party actually appears to be manipulating the process, or, is any of that appropriate? And do you agree this is an open question for us?
It's certainly an open question for your honor. I don't think the court has dealt with this issue before. I see other instances where you can do things other than get the 54B certification or dismissal with prejudice. For example, in the DC Circuit in blue talks about instances where there is an involuntary dismissal without prejudice, where the court in that case is serving as the dispatcher, that would be sufficient. I can envision situations where parties settle cases, where the party, as a result of the settlement, the claims are no longer viable. That would also create finality. In terms of, again, I don't see a lot of the case law looking at the motivations of the party, like having an evidentiary hearing to figure out, why were you doing this? I think there is a presumption that because Rule 54 is in place and there's a mechanism to do this, that dismissals without prejudice following judgment in favor of one party do trigger a presumption that there was an intent to manufacture finality, and that deprives the court of jurisdiction. If there are no further questions on that issue, I'd like to turn to the question of sovereign immunity. We believe the trial court was correct to dismiss the complaint in this case based on the failure to plead sufficient facts to overcome an affirmative defense of sovereign immunity. Judge McLeish, you asked earlier whether it was appropriate to do that, and we believe it was. A plaintiff can plead themselves out of a claim against the district on sovereign immunity. Take, for example, a complaint.
For sure you could, if your complaint clearly indicates that the gravamen of your action is discretionary, then you could plead yourself out. I get that. My question was a little bit different, which is, if you didn't really, your complaint isn't so much focused on sovereign immunity because it's an affirmative defense and you're not, necessarily, my question is in part, do you need to anticipate that? But let's say you just file a complaint and you're laying out your causes of action. And then the district comes in and says sovereign immunity. And can the plaintiff say, well, the complaint doesn't really focus on this because that's an affirmative defense and I wasn't anticipating it. But here is, here are the additional facts I allege that will bear on whether a defense of sovereign immunity should prevail at the motion to dismiss stage. So can you go outside the complaint in responding to a motion to dismiss on sovereign immunity grounds to try to, not to contradict what's in the complaint, but to supplement it to show, if you think you can, that the complaint wasn't clear on this, but now that somebody's demanding clarity, here's the clarity, our allegations are, here are the specific discretionary actions that we're alleging. Is that okay to do, or are they limited by their complaint?
I think they're limited by their complaint, Your Honor. We look at the four corners of the complaint on a motion to dismiss. Certainly, they may seek leave to amend if they have additional facts that they think would support. But
That's not true. Off the top of my head, I'm not sure that's true with respect to some affirmative defenses. You can plead yourself out, as you put it, of things like statute of limitations too. But I thought that sometimes, I thought there was some authority for the idea that you're not required in your complaint to anticipate affirmative defenses. You can kind of shoot yourself in the foot about them by showing in your complaint that they should succeed. But if you don't address them, I didn't think you were limited by the four corners of your complaint. Is there authority you're aware of to support?
I think generally that's the practice, but I would say in this case, Your Honor, that it's the district's view that they did shoot themselves in the foot here. If you take the allegations, they're all directed at discretionary acts. There's no hint of ministerial act to be found in the complaint in the district's view. Now, to your point, Your Honor, sometimes you can get discovery on jurisdictional claims like this, but discovery again is limited to the content of the complaint and whether or not you're going to uncover facts that support the allegations in the complaint. So I do think it's very complaint focused. And here, what the allegations show are challenges to discretionary decision making about the district's systems design of its information technology systems.
Can I just add, just going back to Judge McLeese's point, are you literally saying that in your complaint, you have to say, I'm suing the government and for ministerial action?
No, you don't have to say it, Your Honor, but you have to have plead facts. And I can give you an example. Let's take the software example. In the district's view, the software allegations that we've been talking about are subsumed within the allegation that we didn't adopt the FBI's industry standards. But a complaint could say, for example, the district has a policy of updating its software weekly, and it failed to follow that policy. It didn't update its software for 3 months. And as a result of that, we have the breach. So that is a factual allegation of a ministerial act. So no, you don't have to use the words ministerial act, but you do have to plead facts that would support a finding that the thing you're complaining about is ministerial. And the facts that are pled here all go to discretionary decision-making on the part of the district.
What happens when those facts might be something that only the district would know? And, you know, I know Judge Schwab's dissent in that Aguhon case talks about this. It's a dissent, but it seems to, you know, talk about this as if there's some support out there for when a government agency, the question whether the government agency is engaged in discretionary or ministerial acts is something that only the government knows. And there's a Michigan, cites to a Michigan Supreme Court case saying, you know, it's called McCumming, saying the plaintiffs don't have to plead the specific facts and avoidance of immunity. That may not be the rule here. I don't know. But it, you know, if that's the case, how is the plaintiff supposed to get around the fact that they don't have that information?
Well, Your Honor, like any other plaintiff, I mean, oftentimes when you sue corporations or hospitals, those entities are going to have unique information. But the standards here, we look at, does the complaint plead facts that would support a cause of action in light of the district's right to sovereign immunity? Again, it's immunity from suit, and that includes discovery. So I think it is appropriate to look at the four corners of the complaint, and we're looking for that information.
I did take you though on discovery to concede that, and I think you said something earlier, a couple minutes ago, an argument that at least sometimes a plaintiff who files an action against the government can have a right to limited discovery if the government interposes a defense of sovereign immunity and the defendant can make an appropriate showing that limited discovery on the question of sovereign immunity is warranted. Am I right in believing that you acknowledge that? Or
yes, I would acknowledge that with a couple caveats, Your Honor. First of all, that there's no claim here that, right, okay.
Understood.
And then second of all, Your Honor, usually that discovery is limited to factual disputes arising from the complaint. In other words, they're not entitled to go out and get discovery on new facts. What it is that you can have discovery to support the allegations that are made in the complaint. And there was no disputes here about the facts. I mean, take again, for example, the district's failure to follow the FBI guidance. Even if they went out and got discovery and proved that fact to be true, it gets them nowhere because that's a discretionary decision on the part of the district, whether to accept those industry standards as opposed to the 4 or 5 other industry standards they've identified. So proving that fact through discovery would not aid in the court's assessment of sovereign immunity or the jurisdictional.
So in the district's view, they had to plead what the policy decisions were and then plead a departure from those policy decisions.
Correct,
And
Your Honor.
and they need to figure out what those policy constraints are before they file their complaint through FOIA or other investigations.
District's regulations, yes. Statutes, yes. That would be the district's view. And that's true, again, with any complaint. You've got to plead facts that plausibly allege or support your claim for relief. And here where you've pled facts involving only the district's discretionary decision-making, you haven't pled a claim that can survive the motion to dismiss because it just simply does not allege facts.
Are the district's policies available foiable, I guess, to turn that into a verb.
Your Honor, I don't know the specific answer to that, but not to shoot myself in the foot, but for example, if you look at 6B DCMR, Chapter 31, that deals with record retention regulations for personnel information. And in the district's views, those are very high level in general, but that is an example of something that's out there to be found. Right. So they're not mentioned in the plaintiff's complaint or the brief. So that's all forfeited, but that's just an example of how further investigation may have uncovered some information about the district's policies.
A lot of your answers do seem to circle back around to this idea that the complaint needs to be well designed to respond to a motion to dismiss on sovereign immunity grounds. That you have to foresee that, and you have to really have all the factual allegations you need in it in order to defeat a motion to dismiss on that grounds. And I'm a little unsure whether that's right or not right. I'm not sure it's not right, but again, I would have thought that if, let's say, the action here had been, failure to maintain adequate follow and maintain the systems adopted by the district and policies adopted by the district, which is kind of a little murky about whether that's discretionary or at that level of generality. It seems to me, I needed a little more in order to know whether it's on which side of the very murky distinction, to me at least, between what's discretionary and what's ministerial. And if I'm crafting my complaint originally and just trying to state a cause of action, I might not really have to worry so much about that. But you're saying I need to, in crafting my complaint, I need to think, well, this is a sovereign immunity area. The district may well file a motion to dismiss on sovereign immunity grounds. I need to make sure I have in my complaint every fact that I'm going to try to rely upon in order to defeat a motion to dismiss on sovereign immunity grounds.
Sort of, I guess, Your Honor, I guess the problem with your hypothetical that I see is that allegation that the district failed to maintain its computer systems in accordance with its policies, to me, wouldn't survive a 12B6 motion because it's so general. And if we can, and that's really the standard we're applying here to these allegations, is that they're so general and they go to discretionary decision making. So with Your Honor's hypothetical, I do think you need more facts in that hypothetical, even under 12B6, sovereign immunity aside. But yeah, I think it's the district's view that you do need to plead sufficient facts that state a ministerial violation at this stage.
You don't off the
because
top of your head have authority for the basic idea that your complaint needs to have in it facts that are sufficient to defeat a motion to dismiss on, I don't know, you think all affirmative defenses, or at least this one in particular?
Again, I think it's this one in particular, at least for purposes of this appeal, because it is immunity from suit and discovery. And so we look at the very preliminary stages, and the case law talks about, what are the allegations complained of? And so that denotes that we're looking at the complaint when we're making these assessments. And to direct your court to authority, we've discussed this on pages 33, 34 of our brief. This is how the federal courts adjudicate claims of immunity under the Federal Tort Claims Act. So, I think the best authority for my position is found there. And I do believe it's consistent with how other courts have treated these sovereign immunity issues at the pleading stage. Wright and Miller talks about it being appropriate to dismiss on sovereign immunity at the pleading stage as well. So I don't think.
I think it clearly is. The question to my mind is whether the plaintiff is limited in that process solely to what was in the complaint rather than to additional allegations that are responsive to the affirmative defense.
Right.
That's where I'm unsure.
Okay, and to be honest, I'm a little bit unsure there too, because that's not an issue that's been raised in the case by appellants. So I haven't taken a deep dive on that question, but they certainly have not suggested that or filed anything, at least in the trial court, that it would indicate they had any additional information beyond what's in the four corners of the complaint. And I don't think they've indicated here today that they have any additional information.
I thought it was one of your complaints that they are, I'm a little blurry right now, whether it was in the trial court or for the first time in their briefing this court, that they were identifying additional industry standards and things that hadn't been in the complaint. So I thought that they have tried to go outside the complaint.
That is correct, Your Honor. I was talking more in terms of specific, facts going to actions on the part of the district. Yes, they have identified the two statutes here that they believe.
And also
Kevin-
different industry. I thought they were also floating some additional industry standards.
That too, yes, Your Honor. Of course, yes, yes, but nothing with respect to the district conduct specifically.
So
in terms-
if it's fair to read the complaint as alleging a failure to maintain according to the district's own standards, your response to that is it's just too general?
Yes, absolutely, Your Honor. We don't know what the standards are and we don't know what the failure was. And I think that that needs to be pled. Again, just under a 12B standard, that is just a conclusory fact, deprived allegation that wouldn't survive even outside of the context of sovereign immunity. If there are no further questions, Your Honors, we would ask that the court affirm, or actually we'd ask that you dismiss, or in the
Okay.
alternative affirm. Thank you.
Thank you, Ms. Anderson. We will give you 3 more minutes for rebuttal.
Thank you, Your Honor.
Straight.
In terms of jurisdiction, the question again is, this court asked the appellee to brief why it must be dismissed. That basically to take this court's decision-making power away from it, its discretion away from it, whereas this court has said over and over again that finality is not construed in a rigid fashion. This court has the power to make the decision that this is ready, ripe for appeal. The case law that they gave does not support a must dismiss. It describes cases that are very different, where there were evidence of a manipulative plaintiff and the cases that were moribund and dragged out. That's not the fact pattern here. They're putting all their money on the fact that it was dismissal without prejudice versus with prejudice, and that this could potentially invite additional litigation. Dismissing them without prejudice means it's as if they were never in there to begin with, which is true for an infinite number of parties that could be brought in at a later point. So it has no bearing.
I mean, there are a lot of cases that treat the without prejudice as a relevant fact in the finality analysis.
It can be a relevant fact, but in this particular case, it's not, because the key is, going back to Blue, the courts decide finality, not the plaintiffs. We didn't decide, the court decides. As far as the ministerial versus discretionary, the district very clearly, I mean, it's mischaracterizing the complaint. It's not about discretionary acts solely. It comes down to their way of reading the word implement. Implement does not only mean what decisions do you make, it's make a decision and then carry out the decision. Carrying out the decisions are ministerial acts. Once they made the decision, carrying out those decisions are ministerial. There's multiple case law that supports that, dealing with maintaining the roadways, the sewer system, et cetera. When
Can I ask you, what do you make of your opponent's response to the question sort of toward the end of her argument seemed to be almost like kind of a hybrid of sovereign immunity and 12b-6, saying to the extent there are words like implementation, this is a paraphrase of what I took her point to be, so this is not a quote, but to the extent there are words in the complaint like implementation that sometimes can be on the discretion, the ministerial side of the distinction, the complaint is so lacking in detail about what those were, both in terms of what the policies were and what the actions were that were inconsistent with them, or what the failure of implementation was, that they just flunked 12b-6. And so it's kind of a hybrid of sovereign immunity 12b-6. What's your response to her argument that the complaint is just too, to the extent there are some hints of ministerial acts in there, they're just too vague or conclusory or lacking in detail?
Your Honor, yes, they want to say at the same time it's too broad and it's too detailed. It's too many allegations, but not enough detail. We again, at this stage, in order to determine that there's not enough there, it requires an analysis of the entire complaint. We don't have the time to go through 5 pages worth of allegations. But if this court goes through 5 pages of allegations and agrees with the district that there's not a single one that can plausibly be interpreted as ministerial, then that's your decision. But as someone who's been in cybersecurity for 30 years, it's very clear to me, it shouldn't require an expert though. It's as clear as could be by just taking out the word cyber and look at security and safety, and the allegations are there. I therefore ask the court to reinstate, to reverse the dismissal. Thank you.
Thank you very much. Thanks, Mr. Abraham and Ms. Anderson, for your briefing and your arguments today. And the case will be submitted. The second case on this morning's calendar is number 23 CM 322 and 23 CM 323, Connie M. Johnson versus United States. Whenever you're ready, Mr. Cohn.
Thank you, Your Honor. The starting point for my argument this morning will be to assume that the court agrees with our position in the brief, that it's not adequate for a Superior Court criminal judge faced with a motion, as in this case, for alcoholism treatment in lieu of misdemeanor prosecution, to say, oh, I look at your expert report, it mentions that you suffer from some mental illness. I deny the motion.
Well, that's not exactly what happened, right?
That's how I read the record, Your Honor, but
I mean, the court calls, there's a motion for treatment under 24607. The court at the beginning of the hearing says, well, what about 24608, which disqualifies anyone who has been determined from being mentally ill from getting 607 treatment. Counsel seemingly acknowledges that he was unaware of that statute. And the court says, well, as I read the statute, if your client has a mental illness as defined in the code, that resolves it. And counsel says, well, let me talk to my expert. And then he comes back to the court and says, my expert has indicated that Ms. Johnson does suffer from a mental illness, but it goes hand in hand with her alcoholism. And the court says, well, then as I read the statute, you're not entitled to the relief you are seeking. And defense counsel responds, yes, right. And the court says, then there's no need to have a hearing. But if you read the section differently, I will hear you. And counsel responds, I don't. And the court asks him again 2 more times, do you read the statute differently? And counsel does not contradict him. And the court says subsequently, since you are conceding and your expert report indicates that even if she suffers from chronic alcoholism, that she also suffers from mental illness, then I don't think there's any way you could be entitled to relief under this chapter, right? And finally, the court says at the very end of the hearing, there would be no purpose to be served by having a civil hearing since you already conceded that she suffers from a mental illness, which according to 608 makes this chapter inapplicable. So that's the record, right? That the court says, I'm looking at the statute, tell me why I'm wrong, but it seems to disqualify your client. And counsel says, no, I read it the same way, and acquiesces in not having a hearing.
right. But counsel subsequently filed a motion for reconsideration.
Okay, so we're appealing from the denial of the motion for reconsideration, not from the initial order.
The way you read it, yes, my recollection of the record was counsel put up a little more resistance than what you said, but even taking that, yes, the counsel then went back and brought to the court's attention what the statute said and its implications, which is our argument in our brief.
Okay, and So what do you understand counsel to have said in the motion for reconsideration? What was the argument at that juncture?
At that juncture, in fact, picking up on your honor's reading of what happened, counsel was saying, no, we need a civil commitment determination here, Judge. We need an Irvin Act determination, and counsel specifically mentions Chapter 1 and the Irvin Act. So counsel saying, no, it's not a question of looking at my expert report. It's a question of making a civil commitment determination.
And can I ask you, was the point then and or is the point now focused on, in the words of 24-608, whether your client is correctly viewed as mentally ill, so focusing on those words and what they mean, or is the focus on what, determined and what counts as a determination or who has to make the determination, or is it both of those things that are in play?
Yes. And to answer your question in a direction that will also go to relief in this case, I think it would be inappropriate for a trial judge to, in a criminal proceeding, to then turn into an Irvin Act judge and to start looking into whether the person is, as the Irvin Act provides, mentally ill, dangerous, and the dangerousness arises from the mental illness. That's not the kind of determination that the statute intends and that we, as a matter of public policy, would want a criminal judge to do. We have judges who do civil commitment evaluations of that type, of that dangerousness, mental health type, mental illness type. And so, not sure I've answered your question now, but
Well, it sounds to me like you're sort of suggesting both. And let me just make sure I understand. Focus on the word mentally ill, the phrase mentally ill for a second. From what you were just saying, it sounds as though you're arguing, I'm not sure how clearly this was argued to the trial court, or maybe in your brief in this court, but you're arguing that we should interpret mentally ill to mean meets the requirements for involuntary hospitalization under the Irvin Act.
yes, and it isn't just me, Your Honor. As you know, 608 in the very next sentence refers to the Irvin Act, Chapter.
Well,
12.
yes, it does, but I mean, it doesn't say mentally ill as defined in, so it does refer to it. And it also refers generally to Chapter 5, which includes both involuntary and voluntary hospitalization.
Right.
So what would be the basis for defining mentally ill to mean properly subject to involuntary hospitalization under the terms of the Irvin Act, and not, for example, someone who would properly be subject to voluntary treatment under the Urban Act? Well, where would we get that limitation from?
Well, I think the context in which the proceedings are occurring, chances are if a person is out on the street and being charged with misdemeanors, they have not subjected themselves to voluntary civil commitment, at least at that particular moment in their life. So as a
Well, I mean, chances are they won't have been involuntarily committed yet.
Right.
So neither of those things
That's
are going to
right.
be in train.
I agree, Your Honor. And so, as I answer the question, I do want to make the important point. It's in our brief. I don't think this statute is telling the Superior Court criminal judge, please take a look and see whether one can, based on an expert report, or perhaps even your own evaluation or something in the person's record, whether or not this person suffers from mental illness. The law is telling us mental illness as defined in the Irvin Act for commitment or detention or
Well, the law doesn't quite say that, right? The law says, 608 says, the provisions of this subchapter shall apply to chronic alcoholics who have not been determined to be mentally ill. It doesn't say by whom or how. And then it says the handling of a chronic alcoholic who has been determined to be mentally ill shall be governed by provisions of Chapter 5 of Title 21, which, as Judge McLeese just noted, includes voluntary and involuntary hospitalization. So I guess I would like some clarity as to what the argument is. Are you saying that unless an individual has been civilly committed, they can get, they are eligible for treatment as a chronic alcoholic under 24,607? Is that your argument?
My practical, my
I
answer.
just would like a yes or
Right.
no.
And
You can clarify if it's no, but if it's yes, that would be helpful.
No, but it requires clarification,
Great, okay.
which is that the determination of mental illness under the Irvin Act is one that needs to be made if the government, as it does in Jackson cases where the criminal judge has found the person incompetent to stand trial, the government then has an opportunity, and sometimes it does this, to seek commitment under the Irvin Act. And I see.
But I
the
guess I'm
alcoholism
just
situation.
very confused as to why involuntary civil commitment comes into this. The statute just talks about someone who's been mentally ill. It doesn't talk about whether or not they've been proven to be a danger to themselves or others.
Well,
Right, which is a different component, and that the Commission on Mental Health doesn't go around just saying, I declare you mentally ill and you mentally ill and you mentally ill, right? They look at people for whom petitions have been filed where it is alleged that they are both mentally ill and a danger to themselves or others. So again, what is your argument that should have happened here?
And just picking up on what you just said, Judge, what our argument is that this statute does not broadly empower criminal trial judges to make a determination whether a person is mentally ill. It narrowly, just to pick up on what you just said, Your Honor, it narrowly says if there is a determination that this person under the Irvin Act has this dangerousness, mental illness, and the connection between the two, something the government is free, has the option of saying, let's pause these criminal proceedings. We oppose alcoholism.
And so do you think that this determination of mental illness would happen before the Commission on Mental Health?
No, I think it would go in front of a judge.
So you're
a
talking
civil
about a
judge.
21,545 proceeding, right?
Correct.
The judicial proceeding that is at the end of the road after the Commission on Mental Health has said, yes, we think this person has mental illness and is a danger to themselves or others. You have a right to go before a judge and a jury and get a determination that you should be civilly committed. And that's the proceeding that you think needs to happen to disqualify someone from 24,607.
It would be, to answer your question, Your Honor, the same Jackson. After a Jackson incompetency determination, the government goes to a civil.
So
Judge.
first, the person has to be deemed incompetent,
Right.
and then they have to be civilly committed and go through the entire process.
No, I'm making an analogy to the Jackson situation. I'm not saying this person is incompetent, but I see an analogy between a person coming to the court and
Well,
saying,
competency determination is made before a criminal judge,
right,
right?
right.
But
But
you're
this-
saying
but-
this shouldn't happen before
But
a
the
criminal
mental
judge.
illness determination, that combination of
Right,
dangerousness
and
is
all
not.
I'm asking is, as a practical matter, when and by whom, when does this happen and who makes the decision, right? Your initial brief to this court says there has to be an
Right.
adjudication.
And
By
my,
who
and the answer
and
that I was
when?
trying to give, it would be the same as a post-Jackson incompetence determination. It would be to a civil court judge in the Superior Court who would make the same kind of determination.
But that would only happen after a petition for civil commitment has been filed.
That's right. The government would have that
Well,
option.
Why is that? Again, I'm interested in the practicalities of it too. So let's say that I'm a misdemeanant and I have some mental health issues, and I'm a chronic alcohol I'm charged with misdemeanors. And I'm a chronic alcoholic, and the criminal case has started. And Well, let's say that the government ends up thinking that I'm a danger to myself or others, and they have initiated involuntary hospitalization proceedings under the Urban Act. Let's say that, a police officer has taken me, I was on personal release and a police officer took me to a hospital and started the process. I gather you don't think it sounds as though nothing in the statute here would, on your view, preclude the trial court from issuing an order saying, if the matter was pending, the trial court already had a hearing, the trial court could say, well, you have not yet been determined to have a mental health within the meaning of the statute as you would interpret it. So the trial court could just go ahead and issue an order directing placement of the person instead in alcohol treatment. Is that true or not true? Because if the statute, if the Urban Act doesn't kick in, then the statute seems as though it would permit the trial court to issue a competing order to send me off to alcoholism treatment.
And if I'm understanding your question correctly, Judge, the criminal court judge would have the opportunity to pause the proceedings.
Where is that?
Wait, well,
Because I guess the trial court always could say may.
Yeah.
So that's fair. But
that's right.
let me just ask you then, as you start going through the process, obviously before I could be taken into custody for the purposes of the very beginning of involuntary hospitalization, a police officer or a psychiatrist or qualified psychologist would have to have made a determination. But that's not a determination of adequate in your view, quite clear, right? Then let's say I'm taken to the hospital and the hospital has admitted me. That's not the administrator has made the relevant determinations that you wouldn't count as the determination for purposes of triggering the disqualification in 608, if I understand you, right? But then there is an opportunity under 521, 524, if that process is going on, to go to a court and get a court order very quickly to make a determination about whether hospitalization is warranted. Would that order be the determination, or is it your view that that order isn't the determination and instead the determination that is relevant for disqualification comes, at the very end of the process after the Mental Health Commission has made its determinations and there's judicial review?
I would prefer it to be at the very end of the process. I understand, Your Honor, just to get this thought out. I understand that working out the mechanics of just what determination, whose determination, once one agrees that it's an Urban Act determination, can depend on the circumstances. But at the very least, my position is here that the trial judge erred by simply looking at an expert report and saying this person suffers from mental illness, that a dangerousness component had to be built in.
In defense, I understand your point about dangerousness, but in defense of the trial court on the issue of determination of mental illness without that additional requirement, if it exists, the trial court had the report, and then the trial court had the concession of the defense attorney that I am conceding my client is mentally ill and I don't need a hearing on that. So I think it's a little hard to fault the trial court for taking as a given for its purposes that your client was mentally ill. Now, I understand your legal argument that that's not the determination that you think 608 has in mind. You don't think the trial court even should be making that determination about mental illness simpliciter or without an additional requirement. You think there's a further requirement, and you think if there is that further requirement, the logic and structure of the statute means that needs to be made by a different judge or different entity in a different process. But are you arguing that there was not adequate process? Assume for a moment that mental illness alone is all that is required to have been found by the judge. If that's what the law is, are you objecting separately that there wasn't fair process when the trial court determined that your client was mentally ill?
No, it's not the process that I'm focused on. And again, just Judge Easterly, as we began here, pointedly read the initial concessions that defense counsel made, but defense counsel then made a motion for reconsideration, brought to the court's attention that the Urban Act determination.
So can we focus on that, the motion for reconsideration? The argument, as I understand it, in the motion for reconsideration was that the determination of mental illness had to be made by the Commission on Mental Health. So I'm looking at paragraph 18 of the motion for reconsideration, and the representation is made. Ms. Johnson cannot be considered to be mentally ill as defined under the Urban Act. No petition has been filed under 21-541. No examination has been conducted by the Mental Health Commission, nor has a hearing been held finding her mentally ill. There's no mention of a judicial determination of civil commitment or mental illness. There's no citation to 21-545. So it seems to me that the argument that I think I hear you making, which is there has to be a judicial determination either under 21-545 or perhaps under some sort of emergency proceeding by a judge, that wasn't made in the trial court.
I think it was implicit in the reference to the Irvin Act. The commission, as Judge McLeese pointed out, the commission's determination would be reviewable by a superior court judge. I think the defense counsel ably pointed the superior court to the crucial issue, which we're discussing here, which is it sufficient for you to have looked at my expert report, or was an additional separate finding under the Irvin Act necessary? And yet, and we on appeal and here at oral argument, given the benefit of more thinking about this, have been able to flesh out defense counsel's correct objection that that was the error in the superior court's reasoning.
Can I ask you to we've been focused on the interaction primarily on the interaction between the voluntary provisions of 608, 24-608, where the defendant is coming in and saying, I would like the benefit of this, and the involuntary hospitalization under the Irvin Act. I'm kind of interested in the flip interaction. And what I mean by that is 24-607 has an involuntary part. So if you're a misdemeanant, this could be, alcohol, and you're a chronic alcoholic, this treatment can be forced upon you over your objection. Are you familiar? That's in 607A.
Yes, it continues. Yes.
And you can be put in over your objection. You can be held for up to 30 days to get that treatment. And so let's imagine that I have mental health problems, and they're significant, and I have voluntarily hospitalized myself under the voluntary components of the Irvin Act. And the hospital has made a determination that inpatient treatment is appropriate to address the possibility of danger to myself. If I understand your position, that process is not an impediment to the government coming in under 607 under the involuntary part and kind of yanking me from my involuntary hospitalization, and instead over my objection, subjecting me to 30 days of treatment focused exclusively perhaps on my chronic alcoholism. Is that how you see them fitting together?
I know those are not our facts, but and I'm trying to understand the relevance of the question. So the fact
I'm trying to figure out the implications of
Right.
accepting your view that the meaning of either determine or mental health in 608's exclusion is limited to the process of involuntary hospitalization having gotten to a point where a judge or perhaps the Mental Health Commission has determined that there's the kind of mental illness that warrants involuntary hospitalization under the Irvin Act. And if that's the correct reading of the statute, it seems like one possible implication is that someone who has serious mental health problems to the point where they have voluntarily hospitalized themselves and been determined to be appropriately treated in that way could be, over their objection, forced into alcoholism treatment under 607.
no, if I'm
The 608
understanding,
would not be an impediment.
Judge, no, if I'm understanding your question correctly, that person could say, take a look at 608. Take a look at the fact that a mental health determination under the Irvin Act trumps this alcoholism treatment.
Well, there won't be
voluntary.
any, just to be clear, if I've involuntarily hospitalized, if I have voluntarily hospitalized myself,
Right.
there will be determinations before the hospital accepts me. The hospital is supposed to make some determinations that treatment is necessary for me.
Right.
But no court would made any determination. So if what is needed is a judicial determination of mental health illness of a kind that warrants involuntary hospitalization, there won't be one if I am only involuntarily hospitalized.
Hmm.
So I don't see that where you were headed didn't seem like it was going to solve the problem.
Well, as I understand the question is, let's take our case. The defendant says, give me alcohol treatment, don't prosecute me for a misdemeanor. And the judge says, yeah, but you just voluntarily got yourself admitted to a hospital. Am I misunderstanding?
Yeah, no, I don't, the problem that I see is in settings. I mean, this provision is not that frequently used on a voluntary basis. Off the top of my head, I'm not sure. It's probably even less frequently, if ever, used on an involuntary basis. But it does authorize this being done on an involuntary basis. So what I'm hypothesizing is the misdemeanor does not want treatment in lieu of alcoholism treatment in lieu of prosecution. The defendant would, as most defendants, even chronic alcoholic defendants, most choose not to go this route because it has some downsides too.
Mm.
So assume that the defendant doesn't want it, but the government does. And what the defendant wants instead is to have what is an ongoing voluntary hospitalization treatment of serious mental health issues. And my problem is that if we interpret the language in 608 the way you're suggesting, it seems like the statute doesn't prevent that. It doesn't protect somebody who is in the voluntary hospitalization frame from getting pulled in to something that the person would not prefer, that won't address the person's mental health problems.
Respectfully, Judge, I don't see that implication for this case since
It's not for this case, it's for future cases.
No, I understand. I don't see that. I just don't see how your scenario would follow from our case. The involuntary, the invocation of the involuntary alcohol treatment under 607 is not before this court. So that would be a separate issue, what the defendant could do in that situation, what the government should do in that situation. I don't see it. If there are no further questions, I will sit down. I did not ask for any time for rebuttal.
I'll give you a few minutes for rebuttal. Thanks, Mr. Cohn. We will hear from the government.
May it please the court, Ann Park on behalf of the United States. The trial court here did not abuse its discretion in denying appellant's motion for alcohol treatment in lieu of criminal prosecution. Appellants conceded based on her own expert's diagnosis and proffered testimony that she was mentally ill. And in light of this concession, the trial court, under the plain language of section 24608, ruled that the provisions for treatment in lieu of prosecution under 24607 did not apply to appellant.
So that's the initial ruling. What
Yes.
about the ruling on the motion for
On
reconsideration?
the motion for reconsideration, Your Honor. The plain language of 24608 simply does not support appellant's reading that somehow the determination that is stated there, it has to be a determination made by the Commission on Mental Health or under the Urban Act. All 24608 says is the handling of a chronic alcoholic who has been determined to be mentally ill shall be governed by the provisions of Chapter 5, Title 21, or that is the Urban Act. By its plain terms, it merely provides that treatment for a mentally ill chronic alcoholic is governed or controlled by the provisions of the Urban Act. And that's how the trial court interpreted it at the hearing. She actually said on pages 13 to 14, she says, Chapter 5 of Title 21 controls in cases where there may be comorbidities of mental illness and chronic alcoholism. And in these circumstances, the appellant, quote, may be free to seek some treatment under Chapter 5 of Title 21. That's all it means. And I don't think any of the involuntary provisions of the Urban Act would even apply here because appellant here was voluntarily seeking a treatment in lieu of criminal prosecution. So she very well, because she has mental health issues as well as chronic alcoholism, assuming for the purpose of the appeal that she is a chronic alcoholic, she needs to go to the Urban Act.
It's a weird.
It is.
It's an odd provision though, right? If I'm understanding what you're saying, look, someone who would like voluntary treatment for alcoholism, but also has mental health issues, should go seek voluntary treatment under the Urban Act, which is hard to do if you're being criminally prosecuted and possibly incarcerated.
Yes, Your Honor, but I think that if you look at the statute, it is specifically to deal with the problem of public intoxication and chronic alcoholism when Congress passed it in 1967. When you add mental health issues on top of alcoholism, it gets a lot more complicated.
And isn't there, and maybe this is just that it's outdated, but aren't there very, very few chronic alcoholics who wouldn't have some mental illness that could be diagnosed?
I don't know the numbers, but certainly there, I think two ways to respond to that question. I think there are some chronic alcoholics who are just alcoholics. So they would be diagnosed as having a severe substance abuse disorder, and that's it. They may have other issues, but to be medically diagnosed as having a mental health issue is different from, it's on a continuum, I suppose. But this statute really is only here to address chronic alcoholism. And that's what Congress enacted it for. And that's what 608 says. That's what the plain language of 608 says. I do agree when you look through the legislative history, the notion, they talk about alcoholism as a disease, more like a medical disease. And this is 1967. Certainly our notions of what alcoholism is and mental health and the intersection between the two, they have changed. But it seems to me the DC Council needs to make this legislative fix.
And can I ask you though, I mean, the other strange feature of this focused again, primarily for a moment on the situation where the defendant, the charged misdemeanor would like the benefit of this treatment. I mean, I don't know what the numbers are. Another number we don't know is what percentage of the population would be diagnosable appropriately with some mental illness, no matter how mild. I would expect that's a pretty big number. Who knows leave aside who's actually been diagnosed, but just in terms of if somebody looked into it, whether a diagnosis would be warranted or not. But you take, I don't know, mild anxiety, assume, I would think many folks would have it. And I don't see much logic to why you would say to someone who's a chronic alcoholic who has a very mild mental illness that isn't really well adapted. I mean, it's not remotely the basis for involuntary hospitalization and doesn't really seem like a good fit for voluntary hospitalization. It seems like then they're just out of luck. They can, this is just unavailable to them for no apparent, what seems like a wildly overbroad consequence. So it does seem disturbing.
Well, Your Honor, here the court has to make after, there has to be a medical diagnosis of chronic alcoholism. So the criminal court has to make that determination. But under 608, we're arguing that that same criminal court has to make a determination that the defendant is mentally ill. That doesn't mean has mild anxiety. I mean, there has to be.
Well, I'm not sure. I mean, I guess who knows what all is in the DSM. So I'm assuming mild DSM is a mental health disorder. Mild anxiety is a mental health disorder. But I assume anytime the government did not want the defendant to get the benefit of this, the defendant could say, well, no, we need to have, we either need to ask the doctor who examined the defendant for purposes of determining the existence of chronic alcoholism, or we need to have our own doctor talk to this person and see if there's a diagnosable mental illness. And if, no matter how mild if it is a mental illness as the DSM would identify it, then it's just categorical exclusion, right? It's just not
Maybe
available.
I'm confused. My understanding is to have a clinical diagnosis of anxiety, generalized anxiety disorder, or major depressive disorder. I mean, there are certain criteria that have to be met, and you're not going to be diagnosed. A good psychiatrist is not going to diagnose you with a MDD based on mild symptoms. I mean, there seems to be a criteria that psychiatrists within their profession or psychologists in their profession, you have to meet. It has to be somewhat serious to get a clinical diagnosis. Maybe I'm not understanding it, but I think that's the dividing line. We're not talking about, we all suffer anxiety.
Well, no,
Yeah,
I mean
it's mild. Yeah.
diagnosable.
Diagnosable, yes, and maybe there are continuums, but I think to even get that diagnosis, it has to be a certain level. And we're not.
Okay,
disputing-
but just modify the hypothetical. I have a serious eating disorder. Diagnosable, serious, could kill me, right? But seemingly has nothing to do with whether or not my chronic alcoholism would be better treated through this program, or whether I should go to jail. I don't understand. The statute still seems wildly overbroad.
Your Honor, that's what the plain language of the statute says.
Yeah, I just
I
think one
understand
other.
mental illness and eating disorders, it's a different kind of mental issue, health issue.
Right, can I just give you one other hypothetical just to show the breadth of it? It also seems to be true on your reading of the statute, but I just want to make sure this is right. Assume that I am a charged misdemeanant and I would like and a chronic alcoholic and I would like the benefit of this treatment. And I have a diagnosed mental health, mental illness, but it is entirely regulated right now. So it's not like I don't have it, but it responds perfectly to medication. I take the medication. It does not affect my, as long as I take my medicine, it doesn't affect my daily functioning in any way. You would say just categorically excluded, even though the mental illness is asymptomatic. It's diagnosable, but it's asymptomatic because it responds to treatment.
I think that's a harder question. It's definitely not present here because it's clear from the record that Ms. Johnson was suffering at the time that this hearing was going on from MDD and PTSD and other things. That's what her expert report said. I think that's a harder question. And there is the legislative history, the Senate report does talk about people recovering from mental illness. It depends on the nature of the mental illness. Because sometimes you can be in remission. For example, depression, MDD, you can be in remission sometimes, but it is something that it's a chronic condition as well. It's something that's always kind of possibly can be triggered. If the person is not, if there's a diagnosis that the person has MDD, but right now is not showing any signs of it, or the anxiety is controlled, I think that would be a tougher question, and they may not be excluded under the provisions. That is definitely not what happened here. And I said that I just wanted to point to the courts of the legislative history.
But before you go, what would be the textual basis of the exception that you just acknowledged?
There is none.
Okay.
And I think the plain language makes it very clear that if you are determined to be mentally ill, then you don't receive the benefit of 607. I say that legislative history states that the act applies to chronic alcoholics who have not been determined to be mentally ill. Chronic alcoholism is a separate and distinct illness and is not necessarily associated with mental illness. That seems to me a view of chronic alcoholism at that time. But it goes on to say, it may well be appropriate, on the other hand, to handle alcoholics who are recovering from mental illness under the provisions of the act, and nothing in the bill precludes that. I think that's the question that your honor is asking about the nature of the mental illness and whether it's in remission or you're exhibiting signs of it. And I think it comes down to, you have to have a medical diagnosis that the person is suffering from a mental illness, and you might have to show that they're currently suffering under it, so that treating just the chronic alcoholism is really not going to get to the root of the issue. And I think, the doctor report, as well as defense counsel's proffer on the record at the hearing, he said, look, she has alcoholism and she has these mental health issues, and the mental health issues are fueling her anxiety. She needs to address both. The treatment under these provisions, 24607, pertain purely to alcoholism. So there's no sense in treating her alcoholism if what's driving it are her mental health issues. And so that's, I think, it doesn't say in the legislative history, but that might be what might be driving it. And it certainly makes sense for someone who has both co-occurring conditions of alcoholism and mental health issues to be treated for the mental health in addition to the alcoholism.
Counsel, if I understand Ms. Johnson's argument before this court, it's that what should have happened was that there should have been a judicial adjudication of Ms. Johnson, either a full-blown, judicial finding that she should be civilly committed under 21-545, or perhaps some sort of emergency commitment proceeding by a judge. Do you think that that argument was preserved in the motion for reconsideration? The government hasn't argued plain error.
No, we have not. I actually didn't think I thought he was focused on the determination that there had to be some sort of judicial adjudication in his initial brief. And I didn't think he was actually renewing the argument he made below, that is that the provisions of the Urban Act, the involuntary civil commitment procedures of the Urban Act should be read into the statute. I thought he was not addressing that argument. In any event, I don't think they preserved
But just to
certainly a
return to
545 hearing.
sorry to interrupt, but just to return to what I said to Mr. Cohn is that the motion for reconsideration only seems to reference proceedings before the Commission on Mental Health.
That's correct.
And
he's-
only cites to 21-541, doesn't reference any sort of proceedings before a judge at all.
Yes, that's
So
correct. We did not argue plain error, but I don't think he made the same argument below. He kind of shifted it here. But the 545, the involuntary civil commitment procedures, there's a whole kind of list of things you have to follow until you get to 545. And the plain language just does not support that you have to somehow put in all those specific provisions before a determination of mentally ill can be made here. If you look at the statute, if you look at 607, it says after a hearing, the trial court, the court that has a misdemeanor case has to make a finding of chronic alcoholism after a medical diagnosis and a hearing of chronic alcoholism and adequate services that are provided by the mayor. And we would add, if you want to be eligible under this act, trial court needs to make a determination that the defendant is mentally ill or to be eligible. And that seems to me to be a more plausible and reading all the portions of the statute in conjunction, reading of the statute, or the common sense reading. It just means if you are mentally ill or sorry, you can't get relief here, you're going to have to go to get relief under provisions of the Urban Act. And for this defendant, that would mean the voluntary provisions where the hospital administrator or the director of the clinical services outpatient program that she wants to get into would have to make a determination that she was suitable for treatment there. If there are no further questions, we'd ask that the judgment of the Superior Court be affirmed. Thank you.
Thank you very much. Mr. Cohn, we'll give you 3 minutes for rebuttal.
Thank you, Judge. I note on the reconsideration motion, at least my brief's summary said that defense counsel argued that a Superior Court determination was required. I see that at page 4 of my brief. I don't know, I don't have the motion in front of me, whether I accurately summarized the motion, but that was my reading in the brief. But stepping back for a second, I agree with 2 of the judges who pointed out during this argument that the government's reading is, and it's their words, not mine, would give wildly overbroad reading to the statute. And that's why we argued that that some kind of determination was needed under the Urban Act. The notion that because you're recovering from a mental illness, because it's a chronic condition that comes back and forth, that you're categorically ineligible for alcoholism treatment doesn't make any sense. And therefore we believe that some kind of, that's not what the statute meant. It meant some kind of determination that because of your dangerousness to the community or to yourself arises out of your mental illness, that's something that makes you ineligible for alcoholism treatment. That's what the statute is trying to say.
Your opponent's kind of contrary view is it actually makes sense if you look at it this way, is a paraphrase again, but this I think is the line of thinking that And we have this alcoholism treatment. We have some people there who are good at alcohol treatment, but they're good at doing that when it's a freestanding problem. We don't really have, mental health experts there who can address the interaction between, if there is one, between mental health problems and alcoholism. So the system that we have in mind here is really for the straightforward settings. And if it's more complicated and you need mental health experts, you need to go to a system that is designed to, has people staffed and designed and has procedural protections that are appropriate to those more challenging problems. That's kind of their picture. Why is that an unreasonable picture?
And it's for the reason, actually, I think Your Honor said, which is that many alcoholics are also going to have that alcoholism be related in some way or other.
Well,
to
isn't
some kind
there,
of-
isn't there a textual response too? I mean, the 24607 B2A sub 2 says, look, after finding that someone's a chronic alcoholic, you have to make sure that there's adequate and appropriate treatment available. So for that person who has a co-occurrence of mental health symptoms and chronic alcoholism, if the court figures out that no, there's actually no program that can handle your particular mix of symptoms, then you can't get treatment under 607.
Right, but the court did not make that determination here. And if this court were to take that direction in that reading, that's something that a court should be required to do, which is to make a determination, I'm not going to send you to alcoholism treatment because having looked at your condition, the current treatment, despite, by the way, what your expert says, because the expert was quite clear and recommended specific alcoholism treatment in a specific facility, despite what your expert says, I find that it would not be beneficial to you to be in an alcoholism treatment center, given your other problems. No further questions? Thank you, Your Honor.
Thank you very much. Thanks to both sides for your briefing and your arguments in this case. The case will be submitted. The last case on this morning's calendar is number 23 AA 987, Potomac Electric Power Company versus DC Public Service Commission.
Good morning. May it please the court. My name is Dennis Shamino. I'm Assistant General Counsel for Pepco Holdings, representing Potomac Electric Power Company. For the purpose of the discussion this morning, I'll refer to my client as Pepco or the company. I do appreciate the opportunity to be here this morning and look forward to answering your questions. I would also like to reserve anywhere between 3 or 5 minutes at the end. Okay, thank you. Pepco is asking this court to again remand the decision and direct the commission to follow a process to allocate responsibility for the remedial investigation and feasibility, or RIFS, costs as between distribution, transmission, and generation at Pepco's 77-acre Benning facility site. That's the request. To be clear, Pepco is not requesting the court to conclusively establish the allocation, merely to find that the facts that were relied on by the commission were in error, meaning that the underlying orders were arbitrary and capricious.
Can I also, you're not asking us, this is a question, so I'll frame it better as a question. Are you asking us to direct or express a view about if there were a remand, whether additional evidence should be, that the party should be given an opportunity to put on additional evidence?
I think that would be helpful. I think ultimately the court will decide exactly what it directs the commission to do, assuming there is a remand. But As I read the initial remand order, I think that what the court said there was that there weren't sufficient facts developed or there wasn't sufficient evidence to determine allocation. I think that
I'm not
evidence.
sure we said, if we said either of those two things, I'd be curious to know where we did. I think we said on the current record, we couldn't decide that fact intensive matter. That doesn't really express a view about whether the evidence is there. We're not an evidence
Yes.
deciding entities.
I don't disagree. And in fact, that's what I was trying to get at, which is I do believe the evidence is in the record. What hasn't happened is the litigation and discussion of those facts as among the parties. And I think that comes out in the briefing, both by the commission and PEPCO in this matter. They were the first time really that the discussion of allocation was made in earnest. So to support our argument and the appeal, we have several main points. First, again, while the commission doesn't need to conclusively establish what that allocation would look like among the different functions of the site, the record clearly establishes that the commission's underlying orders were arbitrary and capricious because they were based on erroneous facts. So if you look at the two underlying orders, so right after the court remanded, the commission issued Order 21884. And what it does in paragraph 7 of that order is it says that the RI, the remedial investigation, was triggered by one release. And they said that release was related to the generation site and that therefore PEPCO couldn't recover. PEPCO files its application for reconsideration. And on reconsideration, the next order generally repeats the same claim. And this slightly changes because they begin to talk about, rather than a release at the caulk of the cooling towers, it's talking now about the desludge watering area. The issue with those conclusions, and upon which then they base the ultimate decision, is that none of that's found in the record. So if you go back to either the EPA report, the notice of intent to sue, the consent decree, eventually the final RI report, which goes in obviously much more detail, there's no sole source or sole site for any of it. In fact, looking just at the EPA report, whether it's the conclusion section or the executive summary on page 3, it talks about the historical releases. And none of those historical releases had to do with the sludge dewatering area.
But I thought the EPA report did say that there was one uncontained site, right? Like
That's correct.
my layperson read of the EPA report is that it's saying, look, pretty much everything on the site is paved over, except for this one area that is gravel and dirt. And that's the area that is leaching these polycyclic hyphenols, PCBs.
PCBs.
Yeah,
Yes.
I'm just showing off. So, what couldn't you infer from this report that that's the problem area, right? Everything else is contained, and they talk about how, look, I mean, if somebody went to the site and decided to make it into a recreational area and started digging up stuff, there could be concerns about, toxins from the dirt, from the material they're getting into the air. But really the area that we're concerned about is this area that isn't paved over, and water running through it and getting into the storm drain, going into the river.
Yeah, so I agree that it is an issue.
And and by the way, that's the area where power was generated for 100 years.
Correct. And the company doesn't dispute that. So if this were to get back to the commission, anything related to that area, we would agree wouldn't be recoverable for distribution purposes. But the point of the EPA report is actually broader than that, because it talks about the historical releases. It does not single out that as the only reason for their remedial investigation. And in fact, what they found was that they call it a sludge dewatering area. That was just what they found on that day, because it was a limited test. They also go through in detail, and I think there's a table within the EPA report that shows the various historical releases over time. But even those were only the ones known at that time.
Sorry, I'm getting confused.
Sorry,
We're not talking right now about who's paying for the cleanup.
I agree.
Right? We're just talking about who's paying for and I can never remember the acronym. The
RIFS. Yes.
Yes, that thing. And so your argument is that because this site, because the EPA report shows that there is environmental damage site-wide, that we can't then attribute 100% of the cost to the generating land area.
That's right. I mean, the way I expressed it was the way that the commission apparently interpreted was because only one issue, that was this generation issue in the sludge dewatering area, they said triggered the need for the RI. Then it's all generation related. What I'm saying is, and I'm in agreement with you, there were multiple issues. And then if you look at the final remedial investigation report that comes later, you're going to notice that was correct. In fact, there were multiple PCBs found throughout, including and especially down in the corner where, and I think that if you see it in the briefs, the area around building 56 and 57, that's target area 12. They break these into target areas. And so our point is, not only was it not the sole area, but once you get into the report, you're gonna find that it wasn't even nearly the exclusive area for all these issues.
The Public Service Commission seems to suggest that the 2020 report really wasn't put before it. Do you have a response to that argument?
So it wasn't introduced into evidence originally. So I don't think so. And I wouldn't disagree with the commission if they said that. However, they did cite it in their second order. So after Pepco filed.
And it's sort of an odd thing though, right? Like,
Yeah.
It's got your name on it and you don't put it before the commission at the outset,
Mhm.
and then they rely on it. And then suddenly you're like, well, this is the most important part. This is what you've really got to be focused on. Why
Yeah.
isn't that a fair way of sort of looking at what
Well,
happened here?
yeah, so I think, so what we did include in the initial case, so into evidence was a draft RI. I think it was to give context to some of the activities that were going on at the site. I think what was most likely, and I don't remember exactly what happened, but I think most likely scenario is that evidence had already been introduced in that case. So there may or may not have been an opportunity to do it. I also
Well, the
think,
hearing
was in
was in October,
correct,
but this report, at least the one that I pulled from the record, is dated in February.
it's dated February. What I don't know is when it was actually issued. So I don't know the answer to that. But
Can I ask you?
Yes.
It's sort of related to the topics you've been raising, but a little zooming out a little more abstractly. One picture that it seems like at times you're painting is EPA looked into this. They had some information about multiple spills on the site. There were concerns about the Anacostia River, but there also was just PCBs on the site. And so now people have to look at the site. And the plan is to look at the site as a whole, figure out what problem, all the different problems there might be on the site, and figure out what remediation needs to be done, which could include not really all focused on the Anacostia River and the possibility of pollutants making their way to the Anacostia River, but also problems on the site itself and clean up the site. And I think your opponent's picture and the public services picture is that that's really not accurate, that it's really all about the river in one of the phrases the parties use. And there seemed to be at least some indication that it was to support the latter view of it. One thing that had caught my eye was something that's in the scope of work that was the attachment, I think, to the consent decree, or to the consent decree, or I think to the consent decree. And about the feasibility study piece of it, at least it says, the objective of any landside action is to prevent migration of any chemicals of concern. The objective is to prevent migration of any chemicals of concern to the Anacostia River. So it seemed as though, at least that sentence, maybe not everything everywhere, but that seemed to really be kind of we're not really so much worried about identifying every possible contamination site in the soil here and making sure that there's a cleanup of it. We're really worried about the consequences of problems on the site downstream, literally. And so that's what the focus is. What's your response to whether it is fair to say that the primary focus, maybe the exclusive focus of aspects of this was not so much diagnose all problems on the site, fix all problems on the site, whether they have any implications for the Anacostia or not, or instead look at the site, to make sure that it's not a problem for the river and take the steps that are necessary to make sure the site is not a problem for the river.
Yep, understood. I think a couple points. First thing I would mention is going back to how the commission characterized it. If their position is accepted, why would there be a remediation or a remediation investigation over the entire site? If there was just one thing that they were worried about. Going to the issue that you just raised, that may very well be the arguments that come out if this is remanded to the commission. So maybe that's an issue of allocation, because what I think you're really going to is what's important in remediation. But the question here is really just about those remedial investigation costs and who bears responsibility.
Yeah, but I mean, I take your point that even if one were to think that the concern was ultimately the river, that doesn't necessarily tell you that it's all generation related, because it's more complicated than that. So I take that line of thinking for sure, but in trying to, I guess, understand the context here, to me, at least, it's helpful to know whether you agree or disagree that really this was not there are problems on the site, diagnose all the problems on the site and fix them all.
Mhm.
But instead it was, there are problems on the site. They seem to have implications for the river. We need to investigate the site with an eye towards protecting the river and to take the steps that are necessary to protect the river. Do you think it's the first of those things or the second of those things, which seem
I think
relevant to our assessment of it?
Understood. I think it's closer to the first, which you have because the facility now, as it always has been, but now is focused on transmission and distribution operations. So we still have workers at the site. You want that site to be clean. You want the environmental hazards to be remediated. First point. And you know, I guess the river is it would go into the weighting of how to allocate the cost. The second point I'd say is it in the future, it's likely that part or some, you know, this site could be sold and I think it comes up in the initial case. So just from a public health perspective, even if it's not sold, from a public health perspective, you do want the land to be also remediated. So I don't think that I think attention is properly given to the Anacostia, but it's certainly not the only thing. It's just among the factors that to be considered. The other thing that's probably worth mentioning, if I have time, has to do with the contamination of the river and how it's characterized by the commission, and I think in their briefing. Because if you look toward the end of the joint appendix, it's where we have the final RI, and you can see the maps, and it just happens with the exact same pathway, the exact same stormwater drain from which any potential contaminants would come from the generation, are the same ones that would come from that building 56, 57, that target area that I was discussing that has the transmission and distribution operations. So even if their argument's right, there's still an issue having to do with the transmission. And the PCBs they don't tell you where they're from. They just say, you know, if they are found in either the sediment or in the river, they just say that they're PCBs. I would just say, again, this is why I think this matter needs to be remanded to the commission. There are multiple facts that need to be discussed and vetted and decided there.
And you think that there is evidence already in the record about where the PCBs originated?
No, I don't. What I'm saying is that there is evidence in the record that suggests that there are PCBs found throughout the site.
Right. But is your position that you need to be able to trace all PCBs to the generation facilities in order for this not to be, this cost not to be recoverable?
No. I think our position is, first of all, that wouldn't be possible because that's not what the evidence suggests. The second thing is, I think it's more focused on the way that the commission addressed factually to get it to its conclusion was erroneous based on the record. And therefore it was arbitrary and capricious, which should get us back to factually concluding at the commission what the proper allocation is.
I guess I just would like to know at sort of a high level,
Mhm.
what it is you think the commission needed to decide. Like just, you know, high level outline points,
Mhm.
like what it is that the commission needed to.
I think it goes to what process would be followed at the commission to determine allocation. And there are various ways to do that. And I'm trying to answer your question. If I don't, please let me know. Part of it could be just simple math in terms of the amount of ground at that 77-acre facility that is generation versus transmission and distribution. Some could have to do with the concentrations of the PCBs around the certain areas that had to do with generation and transmission. The point I was trying to make is that none of that was argued by the parties at the commission to determine the proper allocation. Rather, what the commission did after it determined what the settlement agreement and the underlying settlement back from 25 years ago is they jumped from Pepco cannot recover for generation related costs to the generation related PCB releases are entirely responsible for the remedial investigation. And in Pepco's view, that's error.
There's now a final RI study.
Yes.
But the feasibility study, I guess, is ongoing.
It's ongoing, but I'm told that it would be completed this year.
And is it your sense that you need to be acting historically here so that the commission could look at the final RI study and everything that preceded it and hear from the parties and then do some math that seems pretty challenging to me about how to allocate
Yes.
costs among, but it's kind of premature to allocate costs for the feasibility study until you do it. And then you figure out, like, as it turned out, we ended up, $2 million of the feasibility study was devoted to problem A, which is really generation related, and $1 million of the feasibility study was related to problem B, which is really transmission or distribution related.
That's
I was blanking on the third concept. So is it possible to figure out to allocate the FS study costs before it's done, or is that something you think really has to be done in the rearview mirror?
Do I think it's possible? Yes. Typically, the way that things are done with the commission from a cost recovery perspective is we do them, generally speaking, after the cost has been incurred, and we can look back and do the kind of things that you're discussing. Is it possible? I think it would follow the same kind of logic that the remedial investigation does, because these two things, these two parts of the process that are explained in the consent decree aren't the remediation parts. That comes later. These two things are really about scoping out what needs to be done and then eventually targeting that plan, the feasibility study for how to do the remediation. So I think it could be done.
Are you abandoning your DC code to 509D argument?
No, not at all. Be pleased to discuss it if you'd like.
I mean, it struck me that it was interesting that you raised this argument since there was the same problem the first time around, but you didn't object then, right? When the order came out in October 2020.
Oh, the June 21 order?
Sorry?
Is that what you're talking about?
Well, I'm saying when the order came out in your favor in October 2020, sorry, there was a hearing in October 2020, and then the composition of the commission changed.
Oh.
And you got an order in your favor, but you didn't, I believe, have the process that you say you should have had, and no objection was made at that juncture.
Right.
But now that you have an order that is not in your favor, you're saying, oh goodness, we really have to follow to 509D to the letter.
Yeah, well, I guess the way it occurred with the hearing in October of 2020, an order in 2021, the order in June of 2021 actually did have two of the three commissioners that heard the evidence in.
I don't believe so. I think it was Chairman, if I'm correct, I thought the live hearing was before Chairman Phillips and Commissioner Beverly. And Commissioner Thompson was not present.
Correct.
And then Chairman Phillips left before the order was issued. Chairman Phillips left in April. The order was issued in June.
So I believe what occurred is two of the three commissioners that heard the evidence in October of 2020 were then voted on order 20755 in June of 21. The difference is that, and then the commission, I'm sure will correct me if I'm wrong. The difference is now Chairman Thompson came between that period of October 2020 and June of 2021, and he read the record. Pepco doesn't dispute that when you have a quorum, when you have two out of the three, at least, of the commissioners, that an order can be issued without needing to resort to the Administrative Procedures Act that we cite. The difference in this case isn't just that we lost. The difference is that that hearing in October of 2020, only one of the commissioners that was present for that hearing, that personally heard that hearing, then voted on and participated in the underlying orders on remand in this case.
I think I'm not understanding the timeline, but I'll look back at the
Okay.
record. Thanks.
Okay, that is all. Thank you.
Thank you. And we'll give you some time on rebuttal.
Morning, Your Honor. My name is Brian Evans. I'm appearing on behalf of the respondent, the Public Service Commission of the District of Columbia. I reserve 5 minutes for counsel for the Office of the People's Counsel so that he can present his case.
Thank you.
This court vacated the commission's order 20755 as to the approval of the RIFS costs. And if you don't mind, I'll just say RI court costs so it can be clear. Because the court concluded that the commission had actually engaged with respect to the 1999 settlement agreement, whether or not it did or did not bar the recovery of those costs. And the court gave us very explicit instructions to consider whether or not this particular agreement bars recovery of all or some of those costs, and to provide a reasoned interpretation of the 1999 agreement based upon the evidence, and to set out why, under the commission's interpretation of the agreement, those costs were or were not within the settlement's reach. And the commission actually came up with a decision consistent with the court's remand order, and concluded that based on the fact that the EPA report concluded that the lone uncontained source of the PCPs that were discharged in the Anacostia River were coming from or had its origin in the Benning Road Generation Station cooling tower basins, that was sufficient enough for the commission to conclude that because that was the source of the contamination, that was related to the generation facility, that none of the costs would be recovered.
Counsel, I mean, I'm just looking from our opinion in 2022, and we said the exact scope of what costs may be attributed to the generating station is a complex and fact-intensive inquiry that cannot be answered on the record for us. For example, the basic question of how much of the 77-acre parcel of land at Benning Road was used for the generating station has yet to be addressed. I mean, maybe the commission thinks that that question was not relevant, but the commission, as far as I can tell, didn't address that issue in any regard, either to examine how much of the 77-acre parcel was used for the generating station, or to say that that wasn't pertinent to their analysis.
Based on the evidence that was in the record before the commission, Your Honor, the EPA report basically confirmed that the contamination occurred at this Benning station. So the commission did not believe it was necessary to undertake.
But it's not enough to say that there was contamination on the site as a whole, is it? Right? Because the settlement agreement just said, look, anything that comes from generation of power, you can't recover costs for those. But you know, there are a whole lot of other things that are happening on the 77-acre site.
That is true, but as the EPA report confirms, the lone uncontained source of the contamination that actually discharged into the Anacostia his origin was the generation station. I understand.
I guess here's what throws me on that line of thinking. I mean, if that's what the EPA report absolutely established, and nobody thought it was necessary to determine whether that was the case or anything else, you would think that what the actual work that was done thereafter would be zeroed in on that location, that problem, and you'd be just looking right there and figuring out what happened. And if that was what the record would be, then I think the commission would be on sound footing. But it seems like there's a lot of indication that that's not what then happened. That's not what people understood. And instead of thinking, okay, we've got this problem, there's a single leak that we're worried about. It has a single location. It has a single consequence. So let's do some work to study that exact problem. Instead, it's we've got 6 leaks that we know of and reference to historical leaks that we may not know of. And so let's do a broader inquiry. And so the work that seems to actually have been done in significant part, and expected to be done under the scope of work is broader. It's like, look, let's take tests from all around the site and let's figure out what the exact nature of the problem is. So even if, maybe people should have understood the EPA report differently and they ended up doing a lot more work than they should have done. But if they did do that work, unless it was, outside the scope of the scope of work or something like that, it seems like some of that work was directed at trying to figure out whether not only generation, but also transmission and distribution locations were contributing to the problem and needed to be addressed. And that's, I think, kind of in a way, an aspect of your opponent's argument. And what's wrong with that as a way of saying the interpretation you're putting on the EPA report isn't what anybody actually then did. They did a broader inquiry, and that should be allocated as among the activities that the inquiry relates to.
We understand that, but I think it's important to also understand, Your Honor, that we're an economic regulator. We don't involve ourselves in environmental investigations. And I understand that my opponent would wish that, we conduct a more intrusive, deep dive into the origins of the contamination and what was the source, whether it was generation or distribution. But the record before the commission at the time it made this decision was that the EPA report concluded that the only uncontained source was from the generation station. And
so is
and
your
we want to
theory that-
defer
just to be clear, let's imagine that what happened here was that the EPA said, we've gotten a report. There was a report, a complaint by the EPA, or a statement by the EPA that said, we've gotten a report that we don't know exactly where, but there was a leak of pollutants and we need an investigation. And then the district was threatening a suit saying, somewhere on this site, we don't know where, there was a leak and we need to figure out what the problem is. And there was a consent decree that said, we're going to figure out what the problem is. And so let's test all over the site. If at the end of that conclusion, the determination was, oh, as it turns out, the leak was generation related, you would say all of the costs that were attributable to like checking everywhere to see what the problem was should not be allocated to transmission or to distribution. They should all be allocated to what turned out to be the ultimate source of the problem. Is that kind of the line of thinking that you're pressing and that you think the commission essentially was adopting?
Yes, Your Honor. And I think it's important to note that we're going to defer to the EPA. That's the work that they do. They do environmental site inspections. We're only focused on what evidence the company can put before us to decide whether or not to allocate those costs for distribution or transmission or generation. The record reflects that the EPA report confirms that the uncontained source of the contaminants came from the generation station. And that's what the commission relied on.
And what do you make? Your opponent's argument is the EPA report was like a 1 day, here's what we're figuring out. And the whole rest of the process was trying to determine things. And so really, it's not right to think of that report as confirming anything rather than flagging a problem. And the whole idea of the RIFS process was to figure out those answers. And that was a broader inquiry rather than just, okay, we're operating only in the confines of what the EPA flagged.
I understand that, but I think it's important that the district government's letter only came to being as a result of the discovery by the EPA, because it's cited in the DOE's letter, the EPA report as triggering this consent decree that led to the RIFS.
So I have a different line of questioning for that. So assume a different hypothetical. Imagine that there was a very public leak from the facility that was clearly related to generation. So that's what triggered everybody's awareness of the issue. And then people reacted to that by saying, wow, we need to figure out what's going on this site. And then there was a study that was done and a determination was made that actually the problem was not limited to generation, and there were PCB problems being created by activities that were distribution and transmission related. And then people started studying them and spending money on studying them to try to figure out the scope or nature of those problems. Would you say all of those costs should be attributable to generation, because if it weren't for the generation problem that was found first, nobody would have actually figured out or looked into the other problems. Is that your line of thinking? Because that seemed to be kind of a strand of what the commission seemed to be thinking.
Yes, but obviously we'd have to look at the evidence to make the determination as to whether or not there could be some allocation, but again, I'm gonna stick to my, argument that we focused on the EPA report and its conclusions as to what triggered the RI investigation.
Yeah,
And that
it
was-
seems to me that line of thinking probably, I'm somewhat doubtful of it. I mean, maybe I couldn't be less expert in how to allocate costs for rate making purposes among various activities of regulated industries. So take what I say now with as much salt as you need. But if, let's say the situation was, there was a highly public leak that was generation related, and that's what triggered scrutiny of the EPA and everything. And then there was a consent decree that said, solve all the problems here. And it turned out that it cost like $1 million to fix that problem, to identify it, to research it, determine what your remediation would be and implement remediation. But because of the inquiry that was triggered by that, there was an inquiry into, oh my gosh, and also what are we doing about distribution and transmission? And it turns out there's like $100 million worth of remediation, studying and remediation is needed to be done and all of that. You would say, oh, 101 million should be allocated to generation, because if it weren't for generation, nobody would ever have known that there were these other problems. That seems kind of counterintuitive to me, but.
I understand. We would obviously look at the evidence that's presented by the company. In this case, the company did not present, for purposes of the argument that you're making, present that anything associated with the RI was attributed to distribution services.
Well, I said, I think they have, and I think what they think is, at least as far as studying went, there was things that were done that weren't focused on just studying what is the problem with generation. So this triggered, if generation triggered by itself everything, which they also dispute, but if it did, their argument, at least a part of it is, well, sure, but then what was done wasn't limited to generation. There was studying that was done that was on parts of the site that were not generation sites, that were, related to and concerned about possible other historical discharges. And so they do think that they have introduced evidence, at least as an interesting response, why you don't think it is adequate evidence or not even needed to be discussed by the commission. But they think they have introduced evidence that whatever triggered it, the scope of the inquiry ended up spreading out beyond purely generation to transmission and distribution areas of the site and activities.
Yeah, the evidence that apparently they're relying on, Your Honor, is the final remedial investigation report, which was not before the commission.
Well, I think they're relying on things like the scope of work and what it was that people said they were going to do on the site. They're relying on what the testing that was actually done. They're relying on the draft report, which shows what testing was done. So I don't know that their argument is limited to what was in the final RI report. I think it's not an RIFS report because nobody's done FS yet, so it's a final RI report.
But even so, Your Honor, there's nothing in the RI report. I understand what you're putting forth for me to discuss. But from the commission's conclusion, even if we were to consider the final RI report, there was nothing in there that actually rebutted what was in the EPA report. And I think that was what really, for the commission.
Can I ask you also, I'm a little puzzled. I thought it was the commission that relied upon the final RI report. So I'm not quite sure why you say, even if we were to consider it. I thought the commission was the entity that, without anybody introducing it formally into evidence in front of it, did consider it.
Yeah, no, there was an error in the order on reconsideration where there's a reference to the RIFS report, but that really should, and there's a footnote 20, it actually refers to the EPA report. The commission was relying only on the EPA report.
You mean it should have? I mean, it said it was, in its reconsideration order, it said, our conclusion is supported by or consistent with the final RI report.
Yeah,
so maybe it did it. Are you saying it shouldn't have, you're saying that was an error and the commission is acknowledging it shouldn't have considered it, or? But I thought it did expressly make statements about
error
it.
with respect to the reference to the RI report, because there was no RIFS report. First of all, there's only an RI report.
Understood. That's.
But what the commission was referencing is, you can see here on paragraph 11, page 2099 of the joint appendix. It mentions RIFS report, and there's a footnote that says see generally 2009 EPA report. And so that was an error, the reference to the RIFS report. It is the EPA report that the commission focused on.
When you say error, you mean
Scrivener's error.
it? The footnote has as its
The footnote is correct, but the reference to the RIFS report in the paragraph is incorrect. It should be
Right.
the EPA report.
Look, I just am a little puzzled. I get the idea that the commission shouldn't have done that if you think that's right, because it wasn't in front of the commission formally. I get that. But the paragraph that the footnote is attached to says the final remedial investigation report was completed on it, the date that it was finished. And the FS portion isn't completed. The RI report doesn't rebut the EPA's finding. The RI report does not. So, and then there's a footnote citing the RI report, the final RI report. I don't quite get that. How that could be a Scrivener's error. That's like.
I think
a
we're
substantive
looking at two
discussion.
different orders, Your Honor. I'm talking about the order on reconsideration.
That's what I believe I'm talking about. Am I not? It's the September 25th order. In any event, I'm a JA 2096. It's the September 25th, 2023 order.
Oh.
And this is, point 4 is a discussion of the final RI report, says when it's completed, and then discusses its contents and how it does not, in the view of the commission, it doesn't rebut the EPA's finding as the commission describes it. I couldn't see how that was a Scrivener's error.
We're on the right page. You're right.
So
You don't understand what?
I'm not following how that could be a Scrivener's error.
No, it's not. I think we were talking about two different sections. You're right. You're looking at a different portion of the order, but I was talking specifically about paragraph 11.
So with respect to the page 2096 and point 4 of that order, you agree that's not a Scrivener's error.
No,
That
it's
is the commission affirmatively itself citing and relying on that report.
That is correct.
That being so, do you think the commission is in a position to argue that it's not properly in front of it, or that PEPCO can't rely on it, or?
Well, it's important to recognize, what happened was the petitioner placed a copy of the draft report as an attachment to his application for reconsideration. And so the commission addressed that because it was attached. Now, there was no argument or import associated with the petitioner's application for reconsideration that discussed the RI report, the draft RI report, but it was attached to the application for reconsideration.
I have my recollection is different, but I easily could be wrong. I thought that the draft RI report had been admitted into evidence before the fact. It may also have been attached to the petition for the motion to reconsider.
It was, but
it had also been in the record previously.
It was, and it was introduced actually by the OPC witness, not by the company.
That's what I thought.
Yeah. But the final report, which is in the joint appendix before this court, was never introduced into the record. It was referenced by PEPCO witness Terry Sanford as something that was forthcoming, but it wasn't actually introduced or into the record.
So is the upshot of that you on behalf of the commission are acknowledging that it was error by the commission to rely on it in its order on reconsideration because it was not properly in front of the commission?
Well, I would agree that it was improper for the company to mention it, but certainly we didn't need to address it.
The company didn't mention the final report.
Yeah,
Well, what I recall is that the company noted that the final report was a public document.
Right.
That's what I recall in a footnote.
It did. But even though the commission referenced it and made comment, I think the most important import from it, Your Honor, even if it were into the record, was that it did not rebut the findings of the EPA in the 2009 report. And I think the passage of time, it would be difficult to conduct an inquiry at this time to determine whether or not the source of the contaminants came from some other source. I mean, the generation station has long been removed and it's been paved over, and then now to try to do an inquiry 15 years after the EPA has done its report would be really challenging, but certainly it's not within the purview of the commission to make that type of an undertaking. We're going to defer, if you're familiar with the doctrine of comity, we're going to defer to the experts, the EPA. They conduct site investigations. And if there's some additional reporting that comes as a result, we will certainly take that in consideration. But the evidence that was before the commission, we've relied on, as I've continued to say, is the EPA report. which is the one uncontained source. If I may, I'd like to address the argument with respect to 2-509 to provide some clarity. The commission really takes issue with the fact that the company is challenging. I think Judge Easterly, you picked up on part of what I was going to say today, is that when you have a 2-1 decision with Chairman Thompson, currently Chairman Thompson is the swing vote, and there's a notation on, you can look at the Joint Appendix 1426, the first page of Order 20755, there's a notation at the bottom there that says that he personally read the entire record of the base race case. And so now we get to the order 21884, and now the company, to the point that Judge Easterly made, found itself on the opposite side of the decision. And now it wants to challenge the fact that the same Chairman Thompson didn't read the record before rendering a decision in this case.
I didn't think that was their argument. I thought their argument was that he wasn't present, that the requisite number were not present to personally hear the evidence, and therefore that there was a required process of proposed findings and fact and the like. I didn't think that they were complaining about someone not personally reading the record. Am I?
But I think the argument, unless I'm mistaken, I think the argument that is being made is that because he did not even read the record, which my understanding from the Sherman case is permissible, then that would basically render that that would trigger the proposed order requirement in 2-509. That's what I understand.
I guess we can clarify with them, but I had understood their argument to be to take the words personally hear to mean be physically present and have sounds coming into your ears.
Right.
And that didn't happen. And when that doesn't happen, then under 509D, there needs to be a pre-final order, pre-reconsideration and the rest process of proposed order and the like. And there is a requirement of of reading the record for the new person. But I thought that was their that was the argument what was required and what did not happen here. I didn't think they were complaining that someone who was required to read the record had failed to do so.
But I guess the question that I'm struggling with is if he read the record for the base rate case, nearly 200-page order 20755, why wouldn't that similarly apply to him? And he did, by the way, he did read the record for the before this issue of the issuance of 21884. So I don't know where the disconnect is, that whether did he read the first the record for the first case or for the second?
I don't know the
case?
answer to the question of what happened back when people weren't challenging it, because I hadn't understood you to be raising any objection along the lines that they had failed to raise some argument at that stage. So I don't really know there. It may be that this should have happened there too, and that's the logic of their argument. Don't really know. Yeah. But I mean, their argument is: do you think personally? You think personally here can be viewed, can be read to mean read, but don't actually hear in the auditory sense?
Well, when I look at the Sherman case, which basically sets forth, I think the petitioners raised that case. It says as long as the purpose is to make sure that if you're making a decision, you have some understanding of the record, whether or not you personally hear the evidence or you read the record. In this case, he read the record, and it would be difficult for him to having been appointed after the record closed. And I just wanted to clarify that Commissioner Phillips was on the commission and stayed on the commission. He wasn't replaced by Chairman Thompson because we only had 2 commissioners at the time. So he became.
To understand why that makes sense in view of the text of the statute, right? The text of the statute seems to envision having a hearing, a live proceeding where you're interacting with the decision maker. The decision maker can ask questions, you can give answers. But if you aren't there to ask the questions, then they have this different procedure, right? If a majority isn't there to engage in that process, then you have a different mechanism for decision making where that kind of give and take is on paper, right? And so the decision maker puts out a proposed ruling and you get to respond to it, and then comes final. So I don't understand why it would make sense for personally here to mean, oh, you can just read the record, if my understanding of the statute is correct.
Right, and I understand that, but
It's laborious to be sure,
It is.
but it does seem to say that.
I understand what you're saying, Your Honor, and if that is the case, and the court was persuaded by the petitioner's argument, then we would argue that simply order 20755 is similarly infirmed. And therefore, under the court's decision in Meyer versus DC Rental Accommodations, 372 Atlantic Second 566, that both of these orders needed to be reversed by the court.
That's a somewhat belated line of thinking.
I'm just telling you that
And I thought that you had, it seems like you're skipping over at least some of the other points you had made. I thought one of your lines of thinking was that even if this provision was not honored, that the process of being able to file a motion to reconsider and then having the response of the commission on motion to reconsider stood in for it, rendered it harmless. Are you abandoning that argument? Or
no, we're not. In
that's
fact, I was going to say that, what's not in the APA is this reconsideration provision that is applicable to the commission 34-604. And so, yes, we're arguing that if all else, even if we agree that perhaps there should have been some opportunity and we're not conceding that point because we think that the commissioners read the record and that's sufficient for purposes of this decision. But the petitioner has the opportunity to seek reconsideration. That's unique to the commission, probably doesn't apply to a lot of agencies. And so when you look at that statute 34-604 in harmony with the proposed order requirement under 2-509, we believe that that's sufficient due process for the petitioner to contest any decision of the commission. So we're not abandoning that argument, no.
But then your fallback argument is relying on these older cases that seem to treat the lack of compliance with 509D or its predecessor as kind of requiring reversal. You rely on those as sort of a fallback number 3.
Well, yeah, I mean, if the company didn't raise this objection for the order 20755, but is doing it now because this order in 21884 was against the company, then you can't have it both ways. You got to either we have to have been wrong for the first order and this order, or we just got wrong either way.
I'm sorry, the clock is noon, and so I think my brain isn't working as well as it was a couple of hours ago. What does that get you to say, well, both orders have to be vacated? I'm not sure what benefit that.
I promise you that it doesn't benefit me.
Okay.
However, looking at the case precedent that this court has issued in the Meyer case, that's the alternative if you're persuaded by the petitioner. We're not. We believe we've done everything that we were required to do under the APA. And again, to Judge McLeese's comment, our fallback is the reconsideration order. I don't want to have to write another order, Your Honor, I promise you. However, the case law is what it is.
Well, why isn't another option that whatever might have been true about the orders a long time ago that nobody raised, whatever procedural defects exist in those are long ago defaulted, and they're kind of water under the bridge, and we'll take the order that's in front of us and the objections that were raised to it and not unravel prior proceedings on grounds that weren't raised then and really weren't raised now until we're arguing. What's wrong with that line of thinking?
I don't have any objections to that. Does that solve it for you, Judge Solution? Thank you, Your Honor. We ask that the court affirm the commission's decision.
Thank you.
Your Honors, may it please the court, Scott Strauss for the Office of People's Counsel. Let me start with the 2020 RI report. PEPCO's claims about that report should play no role in this proceeding. The document is not in the record. PEPCO never asked that it be put in the record. PEPCO never made a proffer to say what it would show if it had been put into the record. There's a lot of it in the briefs, a lot of statements by counsel about what the report says, but statements of counsel are not evidence. And evidence is what has to decide this case. In addition, PEPCO waived the right to raise argument on the 2020 report by failing to raise it properly on reconsideration. DC Code 34-604 compels that result. The law is clear. You can't raise on appeal contentions you didn't raise on reconsideration. This point is of particular importance to OPC because it bears on our ability to protect ratepayers. OPC had no opportunity to address the 2020 final report because it was never in the record and it was not offered on reconsideration. Where evidence is technical, as obviously would be the case with the 2020 report, which goes on at length, OPC would typically submit responsive expert testimony. But we had no chance to do that in this case because there was no witness who presented the report. PEPCO never presented the report. So any consideration of the report in this proceeding would be unfair and harmful to ratepayers. Now, let me go back to where we are right now. As this court will recall, what's at issue is a single rate making adjustment, or in the lingo of the PSC, an RMA. It's actually RMA number 5, which, as you know, PEPCO proposed in its 2019 rate case, and through which the company sought to charge distribution customers 100% of the pre-2018 costs incurred by the company to conduct the PCB contamination investigation. Now, of course, PEPCO bore the burden to justify approval of RMA 5. As directed by this court in its opinion, the Commission on Remand interpreted the formal 945 settlement and concluded that it contained a broad prohibition. Anything generation related was not to be in the distribution ratepayers' cost of service. PEPCO does not dispute that before this court. The Commission reviewed the record and rescinded its earlier approval of RMA 5. That was the decision they made. That's in Order 21884, and it can be found in the Joint Appendix at page 1746. In doing that, the Commission clearly placed great weight on the statement in the 2009 EPA report that the only uncontained source of the PCBs on the site was unquestionably tied to the generation plant. PEPCO doesn't dispute that either. In their initial brief at page 37, they agree that at the time of the site investigation, the sludge dewatering area was the only uncontained source of PCBs on the site. Now, by itself, that's enough to undermine the prior approval of RMA 5 and the proposed imposition of the 100% of the costs on the ratepayers. The Commission made an allocation decision, which is what you asked them to do. Their allocation decision was 0% to the distribution customers, 100% of these pre-2018 costs to generation. Now, there will be other charges. Remediation hasn't been decided. The feasibility study hasn't been finished. There are going to be other opportunities. But on this record, based on this evidence, that's where the Commission came out.
And what's its reasoning for that?
Like, what is the Commission?
Yeah, what's its explanation about why? I mean, they kind of use the word trigger, and they talk about sole source in the EPA report, which seems to me to be relevant to allocation, but not really a very clear explanation of why you would pick 0 rather than some other number in light of other evidence that seems possibly germane to other numbers.
I hear you, Your Honor. I believe what they were trying to say was, yes, there were 6 spills, but 5 of them were found to have been contained. The one that was uncontained, and in the Commission.
Yeah, I mean, I get that. And let's say that there's a dispute about whether that's the right way of describing all the record, but just assume that it is. If the record shows that the process of studying the issue required expenditure of money on sites that are only focused on transmission and distribution, then it seems like at least possibly those should be allocated to transmission and distribution. And you'd want the Commission to say, well, we get that. There is some evidence of that. That's true. But here's why we still think it makes sense to 0 that out. And we just don't really see any of that.
I mean, the orders are unquestionably terse, Your Honor. But I think what they were basically trying to say, piecing through the reasoning, was that the linchpin and the reason why the investigation went forward was because of the sole uncontained source. And because that seemed to be the linchpin, that it was appropriate in that instance, and given the broad prohibition in the settlement, which the company does not challenge, which came out of this court's opinion, given that it was appropriate to charge the costs entirely to the generation function.
So just on the hypothetical that
Sure.
I asked your colleague, if the way that it's spun out is that it was true, let's say it was unambiguously true that, you know, the EPA report said, right now, the only thing we're aware of is this one uncontained leak. And we're afraid that it might be the cause of what's in the Anacostia, don't know. And then, you know, a study was done and it, you know, it cost $1 million to determine that that leak was a contributor. But the study also ended up, and you could even talk about, you know, the study also then spent $2 million on generation, transmission and distribution areas, and ended up, you know, determining, oh yeah, there's actually, you know, $100 million worth of cleanup we're going to have to do arising out of those activities. You would say because the kind of first cause was generation related, zero out all of the further expenses to study the rest of the problem or to diagnose.
No, I would, no. What we're talking about here is the remedial investigation costs, and actually only a portion of them, the pre-2018 version. And we're trying, I think what the commission was trying to do was to come up with a but-for reason for that investigation. And what they landed on was the 2009 EPA finding that that was the only uncontained source. It is a finding also referenced in this court's opinion, 284, a third at 1030.
I'm willing to assume for purposes of this, that the commission is right to think of that as a but-for cause of the investigation that was done. But wording it in causation terms, as I know your brief did too, I think helpfully. It seems like your opponent's argument is yes, but distribution and transmission are also but-for causes of some of these expenses, because some of those expenses would not have been incurred. They wouldn't have been testing on distribution and transmission and distribution sites if there weren't those activities. So those activities are but-for causes, and every event has an infinite number of but-for causes.
Exactly. That was what I was going to say. Every event has an infinite number of but-for causes. And the commission was trying to identify what they thought was the most significant and the one that actually led to the decision to go forward with the investigation.
That I don't really understand, I guess. Any but-for cause will be a necessary part of whatever it leads to. And so your opponent's argument in causation terms, I think, is there are people studying and doing tests that cost money on transmission and generation parts of the site, and transmission and generation activities are a but-for cause of those expenses. And, you know, maybe the commission could spin out some complex proximate cause theory about how to allocate the multiple causes of that to the multiple costs that relate to it. But the part of my concern is I don't really see that explanation in the commission's order.
I hear you, Ron. And I don't know that I have much to add to what I've already said. You know, the only thing I would point out is, again, that the 2020 report is to the side to this. And I think that's a very important consideration. Thank you, Ron.
Thank you, Mr. Strauss. Mr., am I saying this right? Jamano?
Very close.
Okay.
I'll be brief. Before I start, if there were any questions based on that you'd like me to answer first before I make a few points. Okay. To get to the APA argument, you're exactly right that if you're to boil down what we're saying to one thing, essentially it's the quorum. So it's quorum at the time that there were evidentiary hearings that eventually then leads to which of the commissioners decided which orders. And that's why there wasn't an issue with 20755, the underlying order, because there were two of those commissioners that personally heard the evidence. And yes, now Chairman Thompson came in and read the record later. So that's the APA point from the company. If you look then turning to the EPA report, section 7, and I urge the court to read section 7, the summary and conclusion in its entirety. But when you, pardon me one second. And it's page 25 of the EPA report. And as it goes through it, it does talk about the sludge dewatering area. So that's the generation site. But then there's a sentence right after that talks about an inspection that occurred in 1997. And it includes that this indicates that historical releases of these hazardous substances from the site contributed to the contamination documented in the Anacostia River. So even that section of the EPA report doesn't suggest there's just one site. The second to last point I would make is if you think about the order of the documents included in the record, there was an EPA report, which was from 2008, but eventually there's the consent decree. So when you wonder what the district was thinking about filing the lawsuit, I think obviously the notice of intent to sue, but then you go over to the consent decree to figure out what it was they were doing when they ordered this remedial investigation and eventual remediation. If you look at page 2 of that, and that's on 1763 of the joint appendix, the second whereas clause talks about historical releases. It doesn't talk about the generation site in particular. It talks about all those releases as giving rise to the remedial investigation. And then the last point I would make has to do with, I think there was some discussion about waiver and the remedial investigation report. And the only thing I said, because I think that we've discussed waiver enough, unless you all have questions, is there was a statement made about the RI being in conflict or not with the EPA report. To the extent that it's interesting to you, we're not saying that they're in conflict at all. What the RI report does is in fact provide context. It provides additional context because obviously it was performed over an almost 10-year period. And the EPA report was 1 day. But again, it goes back to the either misuse or misunderstanding of what the EPA report said. So we don't find them in conflict at all. Okay, thank you very much.
Thank you. Thank you, gentlemen, for your briefing in this case and for your arguments. The case will be submitted.
All rise. This honorable court is now adjourned.